Good morning or good afternoon, everyone, depending on where you are. This is the hearing in the annulment case of DS2 SA, Peter de Sutter and Kristof de Sutter versus the Republic of Madagascar, ICSID case number ARB 1718. Welcome to my colleagues in the committee, Ms. Van Leeuwen and Dr. Bottini, who I see on my screen, and to the Secretary, Benjamin Gorel, who I also see. I would first ask the parties to introduce their teams, starting with the applicant, please. Professor Mbenge.
Thank you very much, Mr. President. Good morning and good afternoon, Mr. President, dear members of the committee and dear colleagues representing the respondent in this annulment proceedings. So, Mr. President, the delegation of Madagascar is composed as follows. Madam Raba Manjar Arifera Eliza, who is Director of Legal Affairs at the Ministry of Foreign Affairs. She's actually apologizing for not being able to be here this afternoon because of personal reasons. Then we have with us Madam Rajao Barialena Faratiana from the Litigation Service of the Ministry of Foreign Affairs. Mr. Rajaonezi David, lawyer at the Prime Minister's office. We have also in our delegation Prof. Eric Bjorg as advisor, and of course, Mr. Eran Stoger as counsel and advocate, and myself, Makan Moinsbang, as counsel and advocate. Thank you very much, Mr. President.
Thank you. For the respondent, Mr. Ostrov.
Thank you, Mr. President, members of the committee. So Michael Ostrov, DLA Piper, representing the respondents to the application. With me on the video screen, just making sure that there he is, Mr. Peter de Sutter is here. And then going around the table from me, we've got my colleagues, Mr. Theobald No from DLA Piper in Paris, Ms. Serena Salem from DLA Piper Paris, Ms. Audrey Grisol, DLA Piper Paris, and Charles Dumont de Chassard from DLA Piper in Brussels.
Thank you very much. And we have the transcribers busy already transcribing the proceedings. Can I just ask them if they are content that they are getting the feed clearly?
This is the English court reporter. Yes, thank you.
Same for me, thanks.
Excellent. Do let us know if there's any issue during the proceeding, perhaps by letting Mr. Gorel know. Now, according to the schedule agreed upon by the parties and confirmed by the committee, we start with initial submissions by the applicant for an hour, followed then by the respondent in annulment for an hour with breaks accordingly. Before that, are there any preliminary matters of a housekeeping nature that either party wishes to raise? Professor Mbenge, is there anything you would like to raise at this stage?
No preliminary matter, Mr. President. I just maybe wanted to indicate that I will say a few words of introduction. Then Mr. Stoger will deal with one of our claim, and I will deal with the second one afterwards.
That's well understood. Thank you. Mr. Ostrov, is there anything from your side to raise before we begin?
Similarly, just to say, and again, if the court reporters let us know if there's any problem as we pass the microphone around, that when it comes to our presentation, I will present an introduction and the first half of our response on the first point, and then we'll pass it over to Ms. Grisol, and then Mr. No, and then Ms. Salem, and time permitting, I'll come back at the end. So because we're in the same room and we're trying to adjust microphones, I will try to argue without the headset on. We ask for your understanding, but we have to turn microphones on and off to avoid feedback.
Understood. Understood. Very well. Then, unless either of my fellow committee members has anything that they want to raise at this stage, or Mr. Garel tells us that there's something that we need to raise that I've forgotten, and he's not saying that, then I suggest that Professor Mbeng, we begin with your presentation so that you and Mr. Stoger have the floor.
Thank you very much, Mr. President. Monsieur le Président, chers membres du comité, j'ai l'honneur de me présenter devant vous au nom de la République de Madagascar. Monsieur le Président, depuis quelques années, les pays africains sont engagés dans un vaste processus de réforme en vue de mettre en place un climat d'investissement beaucoup plus serein et prévisible sur le continent africain. L'un des objectifs de ce processus de réforme est de mettre en place des institutions nationales susceptibles de mieux gérer les contentieux d'investissement auxquels les États africains font face et d'éviter la situation dans laquelle la République de Madagascar se retrouve aujourd'hui. S'il est vrai que les États africains, dont la plupart, je le rappelle, font partie des pays les moins avancés, se doivent d'être plus précautionneux sur le choix des avocats qui les représentent dans les contentieux d'investissement ainsi que des arbitres qu'ils nomment, il est crucial que les tribunaux CIRDI déploient également toute la diligence due pour tenir compte des difficultés conjoncturelles et structurelles des pays en développement en général et des pays africains en particulier. La diligence exige, entre autres, que les tribunaux CIRDI fassent preuve de prudence dans le traitement des questions factuelles et juridiques qui se posent à eux afin de garantir la légitimité des sentences rendues. Il en va de l'intégrité du système CIRDI et les tribunaux ont un rôle majeur à jouer à ce niveau. C'est malheureusement le manque de diligence d'un tribunal CIRDI qui a poussé la République de Madagascar à initier la présente procédure d'annulation. Les défendeurs à la présente procédure, par la voie autorisée de leurs conseils et avocats, ont vu et voient peut-être encore le présent recours comme un prétexte pour la République de Madagascar de se délier de ses obligations internationales et de ne pas respecter la sentence rendue par le tribunal. Ce n'est point le cas. La République de Madagascar souhaite réitérer son attachement aux règles et principes de la Convention CIRDI. Toutefois, comme beaucoup d'autres États en développement et développés, africains et non africains, la République de Madagascar pense qu'il est essentiel de faire en sorte que le système d'arbitrage d'investissement repose sur les principes les plus élémentaires de la bonne administration de la justice internationale. La République de Madagascar demeure convaincue que le comité, à qui elle réitère pleinement sa confiance, contribuera au renforcement de l'intégrité du système CIRDI. Mr. President, I will be in charge of dealing with the fact that the tribunal has manifestly exceeded its powers. However, could I please ask you to give the floor first to Mr. Eran Stoger, who will present our arguments regarding the serious departure from a fundamental rule of procedure. Thank you very much, Mr. President.
Thank you. Please proceed.
Thank you, Mr. President. Can you hear me well? Okay. Mr. President, distinguished members of the committee, over the next 25 minutes, I will focus on certain aspects of Madagascar's claim that the tribunal committed a serious departure from a fundamental rule of procedure, and therefore the award must be annulled. My colleague, Professor Mbenge, will then address the applicant's claim relating to a manifest excess of powers. Before I do so, the applicant wants to ensure the committee that it stands behind its written pleadings in their entirety. The fact that we'll focus on certain issues today is not to be taken as suggesting otherwise or that we have given up or are less confident in our position on other issues. Not at all. It's simply that we aim to respond concisely to some matters raised in the rejoinder and avoid repetition. That said, Madagascar is of the view, quite frankly, that there isn't much to respond to. For the most part, we're satisfied that our written pleadings can be read as a direct response to the rejoinder. Mr. President, I recall that Madagascar claims that the tribunal committed a serious departure from two fundamental rules of procedure. First, by not ensuring that Madagascar enjoyed its fundamental right to effective counsel, and second, by reversing the burden of proof in the underlying proceedings. As for the first claim, Madagascar has demonstrated that when the right to counsel exists, it entails the right to effective counsel and adequate representation as recognized by a variety of international and national authorities. In the context of ICSID arbitration, the right to counsel is enshrined in Arbitration Rule 18. Madagascar has further shown that this right to effective counsel is an integral aspect of the right to be heard, a fundamental rule of procedure under ICSID Convention, Article 52(1)(d). Alternatively, the right to effective counsel is a fundamental rule of procedure on its own right that must be guaranteed by an arbitral tribunal. The importance of the right to effective counsel is reinforced by the fact that it's a general principle of law among nations, including in civil cases. Applied to the facts of this case, Madagascar was not adequately represented in the underlying proceedings. However, the tribunal, guardian of the procedural rights of the parties, failed to uphold Madagascar's right to effective counsel. This failure directly affected the outcome of the award. These are the general contours of Madagascar's position. And with that framework in mind, I'll now address 5 general points with examples which the applicant believes will be of assistance to the committee. First, as a preliminary observation, Madagascar's approach towards procedural rights aligns with the view that due process rights involve more than a technical exercise of ticking certain boxes. They must be made effective and real, and if they're truly to be observed. The respondents, on the other hand, seem to support an overly narrow and formalistic understanding of the content of procedural rights. The fact that whether or not an existing right needs to be made effective is still a question for the respondents in 2021 is, in lack of a better word, odd. To demonstrate this, I'll begin with ICSID Arbitration Rule 18. It states in subparagraph 1 that each party may be represented or assisted by agents, counsel, or advocates. For Madagascar, the ordinary meaning to be given to the rule provides for a right to be represented by counsel in ICSID proceedings. The French version of the rule confirms this, using the phrase peut être représenté, and forgive me for my horrid French pronunciation, meaning that a party may or has the power or right to do something. For the respondents, it's only the ability to choose your representative. Frankly, a rule that a sovereign state can choose who will represent it in legal proceedings seems redundant. In any event, the language of Arbitration Rule 18 is clear. A party has a right, if it so chooses, to be represented by counsel in ICSID proceedings. It's true that it doesn't have to appoint counsel, but there's no case law that we're aware of that confines the right to situations where a party must appoint counsel. In theory, parties are not required to mount a defense at all, but that does not mean they don't enjoy procedural rights if they choose to assert them. And that brings me to my second point, that the right to counsel necessarily encompasses the right to effective counsel. Now, first and foremost, I'd like to be clear that saying the right to effective counsel is the equivalent of saying that the right to counsel must be made effective in reality. For Madagascar, as I explained, this seems quite obvious. I note in this context, and more generally, that it's important to bear in mind which proposition each case introduced by the applicant was intended to support. For example, American case law was referred to for the proposition that when a right to counsel, so when it exists, when there's a right to counsel, when it exists, in practice, it means a right to effective counsel and an adequate level of representation. So yes, the seminal case of McMahon v. Richardson, that's DL 269, was in the criminal context. But did the US Supreme Court not explain that when a right to counsel exists, that the right to counsel is the right to effective assistance of counsel? did it not say that the right to counsel guarantees minimal standards of representation and protection from incompetent counsel? The committee in Fraport v. Philippines noted that certain procedural rights, such as in dubio pro reo or nullum crimen sine lege, are only relevant in criminal proceedings. That's DL 262. But as opposed to these two principles of criminal procedure, Madagascar fails to see why, conceptually or practically, the enjoyment of effective counsel would be applicable in criminal, but not civil proceedings. What is clear, however, is that the right to counsel is of limited value if it doesn't go beyond the mere presence of attorney. Like other rights, it must be made effective. Like all procedural rights, it's ultimately aimed at guaranteeing a fair trial. We know that the respondents themselves admit that the right to counsel goes beyond the mere presence of counsel, including in civil proceedings. For example, they admit that counsel must not only be present, but also active. That's in the rejoinder of paragraph 175. Or that presence must be real or effective. That's paragraph 181. In other instances, they positively quote cases that assert that representation must be performed in a concrete and effective manner and to effective enjoyment of representation. That's referring to Bertuzzi v. France, RL 278, and Strachodzic v. Poland, RL 261, respectively. My third point is that these admissions by the respondents also demonstrate that the proposition that the right to counsel is merely an obligation on the state to provide legal aid is unfounded. If that were the case, the mere presence of a state-appointed counsel would have been enough in every case. But clearly that's not the case, as even the respondents acknowledge. Though there is an obligation on a state to provide legal aid in some instances, the scope of the right to counsel is much wider than that. The case law distinguishes between these two important issues. In the two aforementioned cases relied upon in the rejoinder, Bertuzzi v. France and Strachodzic v. Poland, the European Court of Human Rights recognized that there was no right for legal aid in civil proceedings under the European Convention, and yet still found that the plaintiff's procedural rights were not made concrete and effective. We also rely in the memorial on sources that distinguish between the two concepts, and I refer you to footnote 133 of the memorial. For example, the US Supreme Court noted that the right to effective assistance of counsel applies whether counsel is retained or appointed. That's DL 273. An article in the footnote makes the point that the right is not defeated merely because an accused himself employs incompetent counsel who affords inadequate representation. That's DL 276. It follows that the right to effective counsel is a procedural right of litigants in legal proceedings. Legal aid is a separate issue altogether, even if, of course, it's also intended to make the right to counsel effective. Mr. President, my fourth point concerns the differences between the parties as to whether the right to effective counsel is a fundamental rule of procedure protected under Article 52(1)(d), and if so, whether there was a serious departure from it in this case. As for the first issue, the respondents try to set aside the right to effective counsel as part of the right to be heard, because the latter, they argue, is concerned only with providing the parties with an opportunity to be heard. But the committee in Buena v. Egypt stated that beyond the opportunity to present arguments and evidence, the right also entails the ability of each party to respond adequately to the arguments and evidence presented by the other side. That's DL 260. The respondents dispute the relevance of the accepted interpretation of the right to be heard as a right to be effectively heard by the Committee of the Rights of the Child. That's in the rejoinder paragraph 198. On this, the applicants note that the committees in Churchill v. Indonesia, DL 257, and Fraport v. the Philippines, 262, explain why the right to be heard must be interpreted in light of human rights law. In addition, as noted in Venezuela Holdings, an aspect of the right to be heard is the opportunity to fully present one's case. That's RL 286. We believe that without adequate representation, a litigant will not be able to fully present its case. Now, with respect to the right to effective counsel as a fundamental rule of procedure on its own right, its fundamental nature is bolstered by the fact that the right to effective counsel is a general principle of law recognized by the community of nations. In this respect, I recall that Article 52(1)(d) was intended to safeguard fundamental principles of procedural law, and that both of these concepts aim at protecting fundamental requirements of justice. In this regard, Madagascar does not consider that it needs to respond to much, and we refer you to our written submissions, particularly the memorial paragraphs 107 to 155, and the reply paragraphs 129 to 158, and the authorities therein. I will make, however, 4 short remarks on this issue. First, a principle of law need not be uniform, but generally accepted by municipal legal system. That was what the ICJ said in Barcelona Traction, quoted in DL 270, the ILC report on general principles of law. Second, as observed in the study we attached to our memorial, DL 292, 58 states have recognized the right to counsel in a variety of civil proceedings. 15 states provide for such a right in all civil proceedings. The study represented the major legal systems of the world. We also noted that all countries subjected to the jurisdiction of the European Court of Human Rights are bound by such a right. And furthermore, the advisory opinions of the Inter-American Court on Human Rights, not addressed by the respondents, render the right to counsel to the 23 parties of the American Convention on Human Rights, relevant for those 23 countries. Certain states in the United States also recognize such a right, though we admit that here the jurisprudence is inconsistent. And the applicant stresses that these states are those that afford litigants with free counsel. So the list of states that afford civil litigants the right to counsel without legal aid is even higher. Third, the general principle of law has been applied on the international level, as can be seen in the jurisprudence of the European Court, for example, already mentioned. It is completely compatible with the rules governing investor-state arbitrations. And finally, on this issue, Madagascar would like to emphasize that even if quod non, the right to effective counsel is not a general principle of law, that does not mean that it cannot be a fundamental rule of procedure in ICSID proceedings. The point Madagascar was making is that its status as a general principle of law reinforces the fundamental importance of this basic procedural rule. Applied to the underlying proceedings, the tribunal committed a serious departure from this fundamental rule of procedure. On this, I refer you to our written pleadings, particularly memorial paragraphs 156 to 189 and the reply 159 to 191. The respondents say that Madagascar is asking the committee to assess the quality of work of its counsel in the underlying proceedings and to opine on its legal tactics and decision-making. Or that if the committee adopts Madagascar's position, this will lead to some slippery slope where litigants before ICSID tribunals will purposely be inadequately represented. And then they will claim before an annulment committee that there was a serious departure from the right to effective counsel, no less. Now on the latter, I'll just say that it seems far-fetched that litigants will not put forward their best possible case in arbitral proceedings, full stop. On the former, the applicant is not asking the tribunal to assess the quality of counsel or grade counsel's performance. Madagascar has consistently emphasized during these proceedings that their focus is about the responsibility of the arbitral tribunal vis-a-vis the parties, not the quality of its counsel or its choice of legal tactics. Now, this is demonstrated by a passage quoted by the respondents in their counter memorial, paragraph 290 from Wenovi, Egypt. The committee there, in the context of the tribunal's discretion to call witnesses, stated that the principle underlying this possibility is, however, that it is incumbent to the parties to produce the evidence they wish to present. Now, Madagascar could not agree more that this was the responsibility of its counsel, not the tribunal. But that is exactly the point, Your Excellencies, the utter failure of its sole counsel to perform his basic minimal duties. And this failure was undoubtedly serious, as it concerned the one and only issue that determined the outcome of the case: the lack of any witnesses or evidence produced to relate to the night the factory of the respondents was unfortunately destroyed in January 2008. The respondents introduced written statements from one employee, a problematic issue I'll come to back shortly, But from the multitude of people that gathered at the factory on the night in question, counsel for Madagascar failed to produce any evidence or witnesses to challenge the single and self-interested account of the events. This is one of the examples of how Madagascar did not enjoy adequate representation. And for a summary of other examples, I refer you to the reply, paragraph 170. And while we acknowledge that the facts of this case are not identical to others, we note that in one of the cases introduced by the respondents in the rejoinder, a court found that one way that the lack of adequate representation was manifested by counsel was his decision to refrain from cross-examining a material witness, and that's RL 285 in Glaser v. the US. We do not think that that's different from the circumstances of this case. Essentially, Madagascar is making the point that there is a minimum standard of performance that must be guaranteed by an arbitral tribunal in order to preserve the procedural rights of the parties. When no evidence or witnesses are produced, including on the one and only issue, critical piece of evidence, that standard is not met. In such a scenario, it's as if counsel was not present at all. Arbitrators are not passive observers. Such a view of the judicial or arbitral process, Madagascar contends, is quite antiquated. It's at odds with the function of arbitral tribunals under the ICSID Convention. As with other procedural rules, it's the responsibility of the arbitral tribunal to uphold them in order to ensure the fairness, credibility, and integrity of the arbitral process. In the words of the US Supreme Court in McMahon v. Richardson, judges should strive to maintain proper standards of performance by attorneys. That's DL 269. Finally, Mr. President, Your Excellencies, my fifth and final point. Madagascar claims that the tribunal committed a serious departure from a fundamental rule of procedure when it reversed the burden of proof and found Madagascar liable for the destruction of the PGM factory. This was based solely on the written statements of one witness, the deputy director of the security company employed by the respondents responsible for the safety of the property, which was a subject of the arbitration. He was unfortunately unable to participate in the oral hearings. The respondents said very little about this in the rejoinder, so I'll only make a couple of observations. First, the respondents claim that the burden of proof is not a fundamental rule of procedure or even a rule of procedure at all. They rely solely on Teneris v. Venezuela for this proposition. That's DL 247. In our reply, we already demonstrated why the committee in that case, with respect, erred in its analysis, and that there is ample authority that recognizes the reversal of the burden of proof as a fundamental rule of procedure. The respondents' approach was contradicted directly in Ustergetl v. Slovakia, DL 316, which stated that the rule of the reversal of burden of proof is one of procedural order publique under Swiss arbitration law, true, but also that this was similarly the position of international courts and tribunals, including the ICJ and ICSID tribunals, and I quote, is a general principle of law. Also relying on Teneris, the respondents reject the burden of proof as a fundamental rule of procedure because it's not absolute, they say. But few things in life, with respect, are absolute. The committee in Churchill v. Indonesia noted that the right to be heard, and I'm quoting, is commonly considered as not absolute. And that right is unquestionably a fundamental rule of procedure. That's DL 257. So clearly the Teneris committee, again, with respect, erred on this as well. Furthermore, we disagree completely with the attempt to color this claim as one about whether the tribunal accurately applied the rules establishing presumptions or shifting the burden of proof. It is not. Our claim concerns whether the tribunal reversed the general principle of the burden of proof as it applies in international law, which is exactly what the tribunal in Ustergetl v. Slovakia did. Now, as for the facts, we'll refer the committee to our written pleading since there's nothing new to address here. The tribunal determined the culpability of Madagascar based on, as I mentioned, one problematic account of an interested party. Finally, Mr. President, in our reply in paragraphs 200 to 201, We noted the inherent contradiction in the position of the respondents with respect to the behavior of the tribunal. The responsibility of Madagascar was ultimately determined by the tribunal based on the sole written and problematic account of one individual. We say this was a reversal of the burden of proof. The respondents disagree and say that the onus was on the applicant to produce its own evidence to counter theirs, evidence which was undoubtedly sufficient in their view. It is undisputed that sole counsel for Madagascar in the underlying proceedings did no such thing. He did nothing, despite the fact that the case hinged on the facts alleged in this one witness account. The respondents even admit that the critical nature of Mr. Rafa Monezatsoa's account was evident from early on, and that counsel for Madagascar had ample opportunity to do so, and that they in fact challenged him to do so. And I refer you to the counter memorial, paragraphs 249, 291 through 293 as examples. And yet, the respondents refused to acknowledge that this lack of action, alongside other examples, was problematic, and the council did not provide adequate representation on the one issue that determined the outcome of the award. Now, we said in the reply, herein lies the paradox of the respondent's position. Either Madagascar representation was adequate or it was not. Alas, they cannot have it both ways. The response of the respondents on this point in the rejoinder, paragraph 269, is that this is just our assertion, but that's hardly a response. Mr. President, members of the committee, I thank you for your kind attention, and unless I can be of further assistance to you, I ask that you give the floor now to Professor Mbenge.
Thank you very much, Professor Mbenge.
Thank you. Thank you very much, Mr. President. Monsieur le Président, honorables membres du comité, c'est mon tour d'évoquer l'autre moyen d'annulation soulevé par Madagascar dans sa requête au titre de l'article 52.1b de la Convention ICSID, à savoir l'excès de pouvoir manifeste. Dans le temps qui m'est imparti, j'aimerais démontrer que le problème soulevé par Madagascar quant au traitement accordé par le tribunal à la question de sa compétence est des plus simples, et ce, malgré tous les efforts des défendeurs à la présente procédure, de compliquer une question qui est loin de l'être. Monsieur le Président, il va de soi que si la question de la compétence avait été traitée avec célérité, clarté et diligence par le tribunal, nous ne serions pas là à en débattre. Madagascar n'a aucun intérêt à introduire une requête d'annulation ni à se soumettre à des coûts importants dans le contexte actuel de pandémie à des fins purement dilatoires. À l'heure où je vous parle, personne, et je dis bien personne, n'est capable d'expliquer ou de comprendre comment et surtout si le tribunal a traité de l'objection de compétence soulevée par Madagascar quant au choix de mécanisme arbitral. Pour faire simple, tout au long de mon exposé, je ferai référence à l'objection. Cette objection à la compétence du tribunal n'était pas des moindres. Elle était capitale et de nature à empêcher toute sentence au fond dans le différend qui a opposé les parties. Or, si l'objection a été débattue abondamment, in fine, au moment critique de la décision, c'est-à-dire de la détermination de sa compétence, le tribunal a laissé place à un vide sidéral. Autrement dit, rien, ou plutôt rien de compréhensible, rien d'appréhendable, pas de réponse à l'objection. Madagascar ne nie pas qu'un tribunal a la compétence de sa compétence. C'est là un principe cardinal applicable devant toutes les juridictions internationales. Par contre, c'est un principe tout aussi élémentaire du droit procédural international qu'un tribunal doit déterminer et établir sa compétence de manière objective. Cela découle du principe du consentement à la juridiction d'un tribunal, de celui de l'égalité des parties et de celui de la bonne administration de la justice internationale. Le tribunal dans l'affaire Soufraki l'a souligné à juste titre. Je cite, « Compétence is of course not a license for judicial self-levitation. An ICSID tribunal cannot create jurisdiction for itself where none has been granted by the convention and the parties to the dispute. » Fin de la citation. En éludant l'objection de Madagascar, le tribunal n'a pas commis une erreur bénigne. Au contraire, il a commis exactement le type d'erreur pour lequel le système CIRDI prévoit sans aucun doute l'annulation. Permettez-moi donc tout d'abord de mettre en évidence pourquoi l'on peut considérer qu'il y a eu absence de décision, avant de démontrer dans un second temps en quoi cette absence de décision est constitutive d'un excès de pouvoir manifeste. Avant de présenter nos arguments sur ces deux aspects, Monsieur le Président, je dois d'abord évoquer et faire son sort en particulier à une des tentatives de diversion de la part des défendeurs. Ceux-ci estiment que Madagascar aurait dû soulever un autre moyen d'annulation et demander l'annulation de la sentence pour défaut de motif en vertu de l'article 52.1e de la Convention CIRDI. Je vous renvoie sur ce point à nos écritures, notamment les paragraphes 26 et 23, et à la bonne foi de Madagascar, qui a voulu faciliter la tâche du comité en concentrant ses moyens. Il va sans dire que le tribunal ne s'est pas donné la peine de motiver sa sentence. Par leur référence répétée à ce standard, les défendeurs l'admettent même à demi-mot. Néanmoins, un même fait peut engager concomitamment plusieurs moyens d'annulation. Et pour Madagascar, il est évident que la sentence devait être annulée principalement pour excès de pouvoir manifeste. Le défaut de motif, s'il existe dans cette affaire, n'est qu'une conséquence de cet excès de pouvoir manifeste de la part du tribunal. Il va de soi qu'il ne saurait y avoir de motivation sans décision. En d'autres termes, un tribunal ne pourrait motiver ce qu'il n'a pas ou jamais décidé. Les défendeurs admettent eux-mêmes au paragraphe 56.2 de leur duplique, en réponse à notre question sur leur réaction éventuelle vis-à-vis d'une sentence qui se contenterait de dire « pas de compétence », les défendeurs admettent qu'un recours en annulation pour excès de pouvoir manifeste serait pertinent dans un tel cas de figure. Il est maintenant temps de nous tourner vers la sentence afin de démontrer ce qui s'est réellement passé et pourquoi le tribunal a malheureusement commis une erreur fondamentale en ne répondant pas à l'objection de Madagascar. Permettez-moi de retracer le film des événements qui ont mené à la sentence du tribunal. Dans ces plaidoiries, Madagascar avait soulevé une objection de compétence basée sur l'article 12, alinéa 3 du traité bilatéral d'investissement, qui liste l'effort disponible pour les investisseurs souhaitant invoquer une violation du traité. Dans la mesure où les défendeurs avaient d'abord opté pour un arbitrage CCI, l'argument de Madagascar était que ce choix les liait pour la seconde procédure, même si la première sentence avait été annulée. En d'autres termes, le tribunal CIRDI, selon Madagascar, n'avait pas compétence, car cette compétence était réservée au tribunal CCI, devant lequel les défendeurs auraient dû faire renaître le différend. C'était là l'objection principale, la fameuse objection. Subsidiairement, Madagascar a plaidé que pour ce qui est des questions qui avaient déjà été examinées par le tribunal CCI et qui concernent le pourvoi dans l'intérêt de la loi, le tribunal CIRDI ne pouvait en connaître. Il s'agit là de l'objection subsidiaire. Madagascar soutenait donc, comme le montre le prochain diapositive qui apparaît à l'écran, je cite, deux aspects. A, principalement, le tribunal CIRDI est complètement incompétent au vu du choix initial des défenderesses d'arbitrer dans un cadre CCI, c'est l'objection principale, et B, c'est l'objection subsidiaire. Subsidiairement, le tribunal CIRDI est partiellement incompétent quant aux demandes qui étaient déjà devant le tribunal CCI, c'est-à-dire les demandes portant sur le pourvoi dans l'intérêt de la loi. Dans ces plaidoiries, Madagascar a bien réitéré l'articulation entre les deux facettes de l'objection, objection principale, objection subsidiaire, comme en témoigne par exemple le paragraphe 608 du contre-mémoire de Madagascar dans la procédure d'arbitrage, ou encore la façon dont l'objection a été traité par l'avocat de Madagascar à l'audience. Autrement dit, ce n'est que si et seulement si le tribunal n'était pas convaincu par l'objection principale que Madagascar contestait la compétence du tribunal sur une partie des demandes. Cette articulation entre arguments principaux et arguments subsidiaires est classique et n'est pas contestée par les défendeurs. Pourtant, malgré la clarté de la distinction, dans sa sentence rendue le 17 avril 2020, le tribunal en a fait abstraction. Ainsi, dans le résumé de la position de Madagascar qui figure au paragraphe 252 de la sentence, le tribunal a procédé à une synthèse erronée des arguments de Madagascar. Je me permets d'ailleurs de relever que le tribunal a été plus précautionneux dans son traitement des positions des défendeurs. Dans le paragraphe 252 de la sentence, l'objection principale, sans laquelle l'objection subsidiaire n'a plus aucun sens, disparaît comme par magie, laissant l'objection subsidiaire planer toute seule dans l'air, comme cela transparaît clairement du slide qui apparaît maintenant à l'écran. La défenderesse estime par ailleurs, je cite, la défenderesse estime par ailleurs qu'un accord bilatéral sur le recours à la CCI existe en ce qui concerne les questions relatives à la validité du pourvoi dans l'intérêt de la loi, nonobstant l'annulation de la sentence CCI. Les demandeurs ne peuvent donc pas soumettre ce même litige au surdit, vu que l'accord formé en vertu de l'article 12.3 du traité existe toujours. Vous avez là le résumé que le tribunal a fait de la position, de l'objection de Madagascar. Il n'est donc pas surprenant que les défendeurs à la présente procédure aient accepté de reconnaître, d'admettre au paragraphe 119 du contre-mémoire que la sentence n'a pas intégralement reproduit la position de Madagascar. Dans la mesure où le tribunal a décidé de reformuler l'objection de Madagascar, il est encore moins surprenant que l'objection n'ait pas été traitée au bout du compte et que le tribunal se soit limité au langage fort énigmatique du fameux paragraphe 262 de sa sentence qui apparaît maintenant à l'écran et que je cite. Enfin, le tribunal n'estime pas nécessaire de se prononcer à ce stade sur la question de savoir si un accord bilatéral sur le recours à la CCI existe en ce qui concerne les questions relatives à la validité du pourvoi dans l'intérêt de la loi. La compétence étant admise pour que le tribunal se prononce sur les violations alléguées en lien avec le pillage et la destruction de l'usine, le tribunal traitera dans un premier temps cette prétention et déterminera ensuite s'il est nécessaire de se prononcer sur sa compétence pour traiter des autres violations alléguées en lien avec les immixtions alléguées dans la procédure judiciaire. Fin de la citation. L'objection dans ce paragraphe 262 que je viens de citer n'apparaît que sous une forme méconnaissable. On croit y retrouver l'aspect subsidiaire de l'objection, faisant référence au pourvoi dans l'intérêt de la loi, mais qu'est-il advenu de l'aspect principal de l'objection? Quelle est la réponse du tribunal à l'interprétation que donne Madagascar du traité? Nul ne saurait le dire. Nul, sauf les défendeurs qui, dans leur duplique, en particulier au paragraphe 69, entrevoient une réponse dans la seconde phrase tout aussi mystérieuse du paragraphe 262. Mais alors, que signifie la compétence étant admise? Comment admettre une compétence sans l'avoir établie, c'est-à-dire sans avoir déterminé au préalable que l'objection principale n'empêchait pas le tribunal d'exercer toute compétence dans le cadre du différend initial? Cela ne fait pas de sens. L'imagination des défendeurs est encore plus débordante et déroutante lorsqu'ils avancent au paragraphe 82 ou 129 de leur contre-mémoire que le tribunal pouvait se contenter, comme il l'a fait, de retenir sa compétence en général, une sorte de compétence en apesanteur dans le dispositif de la sentence. Il semblerait d'ailleurs que les défendeurs ont plus ou moins abandonné cet argument puisque la duplique ne cite pas une seule fois le dispositif de la sentence. Il en va de même de l'affirmation tout aussi superficielle au paragraphe 121 du contre-mémoire que le tribunal aurait, je cite le contre-mémoire des défendeurs, visiblement, tout simplement adhéré aux arguments sur le fond des défendeurs. Si les défendeurs ont pris un peu de recul par rapport à certains de leurs arguments, ils continuent toutefois de s'arc-bouter désespérément à une analyse très alambiquée tout au long de leurs écritures et dont la teneur semble reposer sur 3 éléments essentiels. Primo, selon les défendeurs, voire le paragraphe 45 de la duplique, le tribunal aurait fait reposer la résolution de l'objection sur la question de savoir si les litiges CCI et CIRDI étaient différents. Ce n'est bien sûr jamais indiqué dans la sentence, mais les défendeurs s'en veulent pour preuve une considération sur ce point, bien qu'ambiguë, trouvée dans la décision sur la bifurcation 2 ans plus tôt. Secondo, deuxième élément de l'argumentation des défendeurs, selon les défendeurs, et on peut voir à ce niveau le paragraphe 122 du contre-mémoire et 48 de la duplique, selon les défendeurs, la sentence aurait traité de l'objection du mécanisme arbitral dans la même sous-section qu'une seconde objection concernant la condition electa ou navia et qui portait sur un litige contractuel devant les juridictions malgaches. Tertio, selon les défendeurs, en particulier au paragraphe 123 et 127 du contre-mémoire et paragraphe 49 de leur duplique, puisque le tribunal a rejeté l'objection electa ou navia après avoir trouvé qu'il n'y avait pas d'identité d'objet et de partie avec le litige contractuel, ce raisonnement aurait tout autant valu pour l'objection portant sur l'arbitrage CCI. Il faut le reconnaître, quel effort vaillant de la part de nos contradicteurs. Oui, vaillant, mais pas convaincant du tout. Reprenons ces arguments un à un. En premier lieu, la condition d'identité, supposément à la base du raisonnement du tribunal, n'est en réalité pas pertinente. L'objection n'en dépendait absolument pas. Ce qui est évident au vu des plaidoiries écrites et orales lors de la procédure au fond. Ces plaidoiries ont par ailleurs eu lieu en majeure partie après la décision sur la bifurcation. Et comment dans ce cas faire reposer tout le raisonnement sur cette décision? Sauf à retenir que le tribunal a préjugé de l'affaire à ce stade, ce qui n'est pas possible et contraire, là encore, aux principes élémentaires du droit procédural international. À ce propos, il faut corriger la duplique. Le tribunal n'a certainement pas dit dans la décision sur la bifurcation, comme le prétendent les défendeurs, je cite, que l'objection de la République de Madagascar ne saurait prospérer si l'arbitrage CCI et le présent arbitrage portent sur des objets différents. Les arbitres ont tout simplement, aux fins de la demande de bifurcation et en vue du contre-argument des demandeurs sur ce point, considéré que c'était une raison suffisante pour ne pas bifurquer. C'était alors légitime. Madagascar aurait objecté, si à en croire les défendeurs, le tribunal avait déjà préjugé du traitement qu'il fallait accorder à cette objection avant même qu'elle soit plaidée. En second lieu, sur le fait que la sentence rassemble les 2 objections dans la même sous-partie. Cela ne prouve rien. Le tribunal était certes libre d'organiser la sentence comme il le souhaite, mais ne pouvait dénaturer la distinction entre les 2 objections. En outre, le tribunal n'indique à nul moment dans sa sentence que la même analyse s'applique ou s'étend aux 2 objections. En dernier lieu, Monsieur le Président, honorable membre du comité, en ce qui concerne la thèse saugrenue que le tribunal aurait juste transposé mutatis mutandis son raisonnement quant à l'objection electa ou navia à l'objection qui nous occupe, il y a un obstacle de taille. Les 2 objections ne portaient pas sur les mêmes litiges. Il n'y a pas de transitivité. Ce n'est pas parce que A et B sont différents que cette différence est pertinente pour A et C. Les défendeurs veulent nous faire croire, par exemple, au paragraphe 124 de leur contre-mémoire, que tout le raisonnement éminemment factuel qui porte sur le litige contractuel devant les juridictions malgaches a été transposé au litige CCI qui, lui, est basé sur un traité devant un tribunal international. Mais ce n'est pas possible. D'ailleurs, cette supposée équivalence entre les 2 raisonnements n'est jamais indiquée dans la sentence et ce n'est pas étonnant puisque, je le répète, la question de l'identité n'était pas pertinente pour l'objection. La lecture des paragraphes 258 à 261 de la sentence confirme bien que le tribunal ne discute alors que du litige contractuel. Sont évoqués tour à tour des termes tels que différents de droit civil contrat d'assurance, litige contractuel et juridiction malgache. Aucune de ces considérations ne s'applique à l'arbitrage CCI et c'est donc à tort que les défendeurs prétendent que l'analyse du tribunal s'y étend. Enfin, la thèse des défendeurs est incohérente. Si le tribunal avait vraiment conclu que les deux litiges étaient différents et que cela suffisait à rejeter l'objection, pourquoi alors garder l'argument subsidiaire et le rejeter au final pour des raisons d'économie procédurale? Il aurait suffi au tribunal, puisque c'est la thèse des défendeurs, de dire les litiges sont différents. Les litiges sont différents et c'en était fini. Pour résumer, Monsieur le Président, honorables membres du comité, tout ceci n'est pas très sérieux. Il est clair que le tribunal a commis une erreur dans son traitement de l'objection de Madagascar. Il a fondamentalement dénaturé l'objection soulevée par Madagascar au point de ne pas y répondre et de l'ignorer de manière flagrante. Les arbitres ont tout simplement omis de traiter de l'objection principale et se sont concentrés sur l'objection subsidiaire. Ils ont considéré que Madagascar ne remettait en question la compétence du tribunal que pour les demandes liées au pourvoi, alors qu'à titre principal, c'était la compétence entière du tribunal qui était contestée par Madagascar. Madagascar avance cette hypothèse avec la gravité qui s'impose, car il n'est jamais évident de pointer les failles d'un tribunal, surtout aussi éminent. Toutefois, et c'est notre conviction, la sentence résulte d'une erreur fondamentale. L'erreur est humaine. Il y a des centaines de tribunaux CIRDI et tout autant d'opportunités de se tromper. Il est dommage qu'une telle erreur ait vicié cette sentence en particulier, mais c'est malheureusement le cas. Et le comité doit en tirer respectueusement toutes les conséquences juridiques. Il en va de l'intégrité du système CIRDI. Et cela m'amène, Monsieur le Président, à mon second point, à savoir qu'il va de soi que cette erreur manifeste mérite annulation pour excès de pouvoir manifeste. Le mécanisme d'annulation en vertu de la Convention CIRDI est précisément dédié à corriger ce genre d'aporie. Peu importe les raisons à l'origine d'une telle erreur, peu importe les raisons à l'origine d'une telle erreur, il demeure que le tribunal a occulté une question au cœur de sa compétence et a commis de ce simple fait un excès de pouvoir manifeste. Il ne fait guère de doute, et ce sera là le dernier aspect de mon exposé, que les critères pour invoquer un tel moyen d'annulation sont remplis in casu. Comme l'a souligné le comité Perenco, comme vous pouvez le voir à l'écran, des minor or inconsequential errors ne sauraient donner lieu à un excès de pouvoir manifeste. A contrario, une erreur majeure ou conséquente se doit de donner lieu à une annulation, surtout lorsque cette erreur a trait à la compétence. Il ne revient pas au comité, comme l'y invitent subrepticement les défendeurs, de déterminer si l'objection avait une chance de succès. Il lui faut juste vérifier que la manière dont le tribunal a rempli sa fonction arbitrale correspond aux principes de la Convention CIRDI ainsi qu'aux principes généraux de la procédure devant les tribunaux internationaux. Dans ce contexte, le comité aura sûrement été surpris, tout autant que Madagascar, par le choix des défendeurs de traiter longuement du fond, voire par exemple les paragraphes 144 à 164 du contre-mémoire, ou encore les paragraphes 115 à 131 de la duplique, traiter du fond afin de démontrer que l'objection était vouée selon eux à l'échec. L'on se croirait revenu 5 ans en arrière quand Madagascar avait dû faire face aux exacts mêmes arguments et espérer que le tribunal y réponde. En omettant de statuer sur une question qui mettait en doute sa compétence in toto, le tribunal a commis un excès de pouvoir manifeste. Si Madagascar avait raison, ce que la sentence ne résout pas, le tribunal était incompétent. Cette erreur n'est donc pas sans conséquence, pour reprendre les termes du comité dans l'affaire Perenco. Et puisqu'elle laisse un doute sur la compétence, pourtant essentielle, du tribunal sur le différend, cette erreur remet en cause l'intégrité de la sentence ainsi que son bien fondé. Monsieur le Président, chers membres du comité, je comprends tout à fait que les défendeurs tentent vaille que vaille de justifier leur position. Toutefois, il me semble que de bonne foi, même leurs conseils avisés ne pourraient nier que le tribunal avait un devoir de répondre à l'objection principale de compétence soulevée par Madagascar quant au mécanisme arbitral. La règle 47 du règlement de procédure du CIRDI dispose que la décision du tribunal doit porter sur toute question qui lui a été soumise. Toute question qui lui a été soumise. L'interprétation du terme question ne doit certes pas inviter un tribunal, les parties ainsi que le comité à tomber dans un formalisme excessif. Toutefois, cela ne signifie pas qu'un tribunal pourrait réduire à néant les questions qui se posent, faire du pick and choose et estimer qu'il n'y a qu'une seule question à trancher lorsque plusieurs questions sont en jeu. Le contre-mémoire des défendeurs, par exemple, dans les paragraphes 82 et 129-130, repose sur l'idée que la seule question qui importait était « y a-t-il ou non compétence ?» et que partant, le tribunal pouvait se contenter, encore une fois, de retenir sa compétence en général, en une phrase et de façon purement abstraite, sans encourir d'annulation. Cette énième thèse des défendeurs est bien entendu des plus pernicieuses et vide de son sens ainsi que de son effet utile le système unique d'annulation mis en place par la Convention CIRDI. Elle ôte tout pouvoir et marge de manœuvre au comité ad hoc. Comment en effet vérifier que le tribunal a répondu spécifiquement à toutes les questions et donc qu'il n'a pas commis d'excès de pouvoir manifeste s'il lui est loisible de décider de l'affaire en général? Il est évident que les défendeurs eux-mêmes auraient introduit une requête en annulation si le tribunal avait jugé à l'inverse qu'ils n'avaient pas compétence sans tenir compte de leurs objections. De même, les défendeurs auraient protesté si la sentence s'était contentée de dire que Madagascar l'emportait sur le fond sans traitement de leurs griefs ou de leurs réclamations. Ils ne soutiendraient vraisemblablement pas, comme ils le font aujourd'hui, que le tribunal a correctement fait usage de ses pouvoirs. Alors pourquoi reprocher à Madagascar de demander, comme lui permet la Convention CIRDI, une annulation en vertu de l'article 52.1b? La doctrine inédite des défendeurs du général est suffisant en soi ne tient pas la route. Le tribunal lui-même a choisi de répondre à chacune des autres objections de Madagascar et n'a pas décidé de le faire en bloc. Bien au contraire, les passages de la sentence portant sur la compétence, à l'exception de l'objection qui nous occupe, témoignent du souci du tribunal de remplir sa mission et d'établir sa compétence. Cela ne rend que plus flagrant son refus manifeste de résoudre l'objection quant au choix de mécanisme arbitral. Monsieur le Président, honorables membres du comité, cela conclut mon propos. La République de Madagascar invite le comité à confirmer que la sentence repose tant sur une inobservation grave d'une règle fondamentale de procédure que sur un excès de pouvoir manifeste et se doit donc d'être annulée purement et simplement dans son intégralité. Je vous remercie de votre attention.
Merci beaucoup, Professor Mbeng. Do either of my colleagues have any questions that they wish to raise at this stage, or do they prefer to reserve any questions until the question session that we have at the end of the day?
I would prefer to keep questions until the end of the day.
Very good.
Yes,
Gabriel?
me too, yes, afterwards.
Very good. So we'll reserve any questions that we have. I think now we have a 15-minute break, and then we'll come to you, Mr. Ostrov. Very good. So it's now exactly 2 o'clock London, 9 o'clock, I guess, in New York. So 3 o'clock in Paris. So if we come back at 1:15, whatever the hour is. Thank you. Mr. Ostrov, do we have everybody who you need on your side present?
We do, Mr. President. Thank you.
And is everybody who needs to be present on the applicant side as well? I can see Mr.
Yes,
Steger
yes,
and
yes,
Meng.
yes, Mr. President. Yes, Mr. President. Thank you.
Welcome back.
Mr. President, I see that that Ms. von Leeuwen is may have issues with her webcam, and I'm saying that because I have myself issues with my webcam. The Zoom saying that they cannot recognize it anymore. So I'm wondering whether it's the same issue that she's facing.
I can see
I
very
don't
well.
have any issues with the webcam that
okay,
I'm
so
aware
then-
of. I can
so-
see you, and I think I'm visible for the others too.
All right, I'm sorry. So then there's an issue with mine. I apologize. I cannot see Ms. von Leeuwen, but that's okay.
And
Yes,
we no longer
we
see you,
can't
Mr.
can't see you, Mr. Gorel.
Yeah, that's what I'm saying. My camera is. You don't need to see me, I assume. So I'll try to fix it, and I'll be back shortly.
We'll try to survive without seeing you. Mr. Ostrov, with that, do you want to begin, please?
Thank you, Mr. President. I'm just going to start with a bit of procedural history and a figure to bear in mind. 12 years and 10 months. That's how long two brothers, Peter and Kristof de Sutter, have been waiting for indemnification in this case. And those two brothers have done absolutely everything by the book. They have won on the merits on their case 4 times, twice in domestic tribunals and twice in international tribunals. 12 years and 10 months after the loss of their factory, this is a case of a total destruction of an industrial investment. They invested millions of euros in Madagascar starting in 1998. By 10 years later, they were up to approximately 1,000 employees, making them a major employer in the region. And on January 27th, 2009, 12 years and 10 months ago, rioters attacked the industrial site where their plant was. Total destruction ensued of the production units, the factory, the stocks, the offices. Law enforcement had been warned and they ignored it. They arrived late when called, when the rioters were arriving. They remained passive while the rioters went in and began destroying everything. And they left early because they said they had to go have dinner. The de Sutter brothers were obviously devastated by what happened. But fortunately, they were insured. So they made a claim to Ni Havana, their insurance company there, which is a state-owned, major state-owned insurance company, and Ni Havana denied coverage. So the de Sutter brothers went to local court, and they won in the first instance, and they won on appeal, nearly 6 million euros under the insurance policy to indemnify them. And then everything went wrong because Ni Havana asked for some assistance from the government, and began years of state interference with the justice system, which started with the government freezing the enforceability of the award, of the local judgment, by filing what's called a pourvoi dans l'intérêt de la loi. And that's what triggered the ICC bilateral investment treaty claim, a claim for the justice being delayed by the government action. And the ICC tribunal awarded the Sutter brothers and their company, PGM, compensation for that. And through no fault of the claimants in the arbitration, that award was annulled because of a procedural error by the arbitrator. And after that annulment, the state became unrestrained. There was massive interference in the judicial system. The file was sent from the courts to various ministries. The state went so far as to change the judges on the Supreme Court before the case was heard. So in 2017, 8 years after the destruction of the factory, with no compensation, with ongoing interference, the Sutter brothers filed a new claim, this time coming to ICSID, and this time raising two separate claims that are called in the award Voie 1 and Voie 2. Voie 1 was seeking damages for failure of full protection and security. Nothing to do with the court proceedings. It had to do with the ineffectiveness of the state police powers to protect the investment. And the second claim, Voie 2, was for a denial of justice. This time based on numerous acts that took place after the ICC award, in addition to the initial pourvoi dans l'intérêt de la loi. And state was represented in the ICC proceedings and in the ICSID case by one of the leading specialists of international investment law in France, Professor Walid Ben Hamida. There was no real defense to present on the merits in light of what had happened, but he fought the fight of complexification. All imaginable arguments were raised, and even many that one would not have thought imaginable. And the tribunal was not fooled by any of that. The case took a long time because of that method of fighting, but the multiplication of all the different arguments only served to demonstrate that there was really absolutely no defense on behalf of the state. And in the award of 17 April 2020, the ICSID tribunal found the state liable, responsible for a breach of full protection and security, and granted damages on Voie 1, on the first claim, full protection and security violation, and did not need to consider Voie 2, the denial of justice claim. Madagascar's efforts to delay any payments to the Sutter brothers and their companies would not stop there. It filed the annulment action in August of 2020. I would ask the committee to recall that annulment is not automatically it's not a required stage in every ICSID arbitration. Annulment is a limited recourse that is designed to deal with serious procedural systemic problems. And here, the award is complete on the issues. It's a perfectly reasonable award after a full and fair hearing in front of a tremendously qualified tribunal. But with no case, Madagascar has turned to additional brilliant international jurists to handle their claim. And I say that with absolute full respect for opposing counsel. They are brilliant international lawyers, and they have put the fullness of their abilities to try to create something out of nothing. 12 years and 10 months. And our clients sit there wondering, as small business owners, what is this international justice system and these bilateral investment treaties? All they've seen so far is a lot of expensive lawyers and expensive arbitral procedures. We've already demonstrated in writing, and what we're going to review with our time today, is that the tribunal did not exceed its powers at all, let alone within the meaning of Article 52(1)(b) of the ICSID Convention. I'll cover that, and then the question of whether any such excessive powers could be manifest, which is of course the requirement, will be dealt with by Ms. Grisol. And the tribunal did not depart from any fundamental rule of procedure. Madagascar has mischaracterized a principle that applies before domestic courts in certain circumstances and manufactured out of whole cloth a non-existent right that could never apply in an ICSID arbitration. And my colleagues Theobald No and Serena Salam will deal with those. So turning to the manifest excess of powers. This argument is grounded on the completely false idea that the tribunal failed to decide one of Madagascar's objections. Where did Madagascar get the idea that one of their objections was not dealt with, was not decided? It's based on a pure misunderstanding of the award. They thought that the tribunal had wrongly concluded that Madagascar admitted the tribunal's jurisdiction over the full protection and security claim. This is what they said in their memorial on annulment, paragraph 6. The tribunal asserted groundlessly that Madagascar had, quote, admitted to the existence of a jurisdictional basis that was in fact vigorously contested. And we've demonstrated that this error, because that never happened, is fatal to the annulment case. And the tribunal did not exceed its powers. So today, the committee needs to answer two questions, and it would need to answer both questions as yes, if it were to consider annulling this award. Was there a manifest excess of powers? Was there an excess of powers at all? And if so, would it be manifest? And we submit to you that the answer to both of those questions is a resounding no. So with respect to the first of these questions, what are we talking about with an excess of powers? Most usually what we see is a claim that an excess of powers is where a tribunal made some kind of fundamental mistake about its jurisdiction, like finding that someone who's a national of a state could bring a claim against its own state, where someone does not fulfill the definition of an investor, or something does not fulfill the definition of investment. There's actually no claim here that the tribunal made an erroneous determination about its jurisdiction. There's no claim that it exercised jurisdiction that it does not have. The claim here is that the tribunal failed to decide the question of whether it had jurisdiction to hear our full protection and security claim. And that was confirmed in the argument you just heard in the last hour, where Professor Mbengue said, "Personne n'est capable d'expliquer ou de comprendre comment et surtout si le tribunal a traité l'objection de compétence soulevée par Madagascar quant au choix du mécanisme arbitral." I assure you, we can, we have, and we will once again show you that the tribunal did treat that question, decided that question, and ruled against Madagascar on that question. Of course, we accept that an arbitral tribunal must decide the claims that are submitted to it, and it exceeds its powers if it fails to decide a question when it had the jurisdiction to decide that question. And Professor Schreier, in the quote that you have on the screen, explains that, could you go back? Sorry, Charles, thank you. That it is not within the tribunal's powers to refuse to decide a dispute or a part of a dispute that meets all the jurisdictional requirements of Article 25. Fine. On the other hand, the tribunal does not exceed its powers if it does not specifically analyze in detail all of the arguments laid out by the parties in support of one of the claims. And I'm going to come back to that in a little bit more detail later. And in this case, what's clear is that the tribunal absolutely did decide the question about jurisdiction raised by Madagascar. Along with 24 objections as to the admissibility of the claims, 24, Madagascar raised 6 objections to the tribunal's jurisdiction. We're down to 2 of these objections that are relevant here. If we could go to the next slide, the 5th objection that they made was a classic fork in the road objection under Article 12(2) of the BIT, which you have here, which is that the différend sera soumis au choix de l'investisseur, soit à la juridiction soit à l'arbitrage national, soit la juridiction compétente de l'État, soit l'arbitrage international. A classic fork in the road position. It was a pretty silly argument. It amounted to saying that the contractual claim that Nihavana had to pay the insurance cover was the same dispute, le différent, as the investment treaty arbitration that was brought. The sixth and last objection, go to the next slide, please, was Madagascar's choice of forum objection based on Article 12.3 of the bilateral investment treaty, where if the claimant has gone to international arbitration, then le différent sera soumis à l'un des organismes d'arbitrage désignés ci-après au choix de l'investisseur, ICSID or ICC. And Madagascar argued that because our clients submitted a claim to ICC arbitration, that its claim, whatever that claim might be, could never be, even after the ICC award was annulled and was non-existent, could not be brought to ICSID. Next slide, please. The primary argument by Madagascar was that all of the claims submitted to the ICSID tribunal were covered by this choice of forum objection. Madagascar stressed that Article 12.3 offered just a choice between fora, and once you made that choice for anything, it was irrevocable. As a result, they said, and now I'm quoting, it's on the screen, paragraph 47 of their memorial, as a result, the respondents could not submit to an ICSID tribunal the same dispute as in the ICC proceedings, and thus the tribunal, they said, lacked jurisdiction under Article 12. Now, recognizing the obvious, patent, blatant flaw in their argument, at least with respect to the full protection and security claim, which was never raised in front of the ICC, Madagascar hedged its bets, and it presented an alternative argument, which was that even if the tribunal doesn't accept its choice of forum objection with respect to full protection and security, they argued, well, it has to apply to the denial of justice claims because the ICC tribunal had heard the question about the pourvoi dans l'intérêt de la loi. And Madagascar's theory today is that the tribunal ignored the first part of its sixth objection, its choice of forum objection, that everything was the same dispute and had to be and had to go to the ICC, and then failed to decide it. But that is just not what happened. From the outset, it's absolutely clear that the tribunal understood what Madagascar's objection was all about. Madagascar agrees that the tribunal initially understood that. That's at paragraph 57 of its memorial. And the tribunal itself, in its decision on bifurcation, it's not that it decided the question at that time, but it clearly understood both the objection and how patently prima facie ridiculous the argument was. Because it said, à première vue, just looking at it like that, l'arbitrage CCI et cet arbitrage portent sur des objets différents. And it goes on and gives some detail about that. And for that reason, it said, we're not bifurcating, we're not slowing this case down more on that, we're going forward, we'll deal with it later. During the final hearing, we could go to the next slide, please. The president, the president asks if there are other frustrations exprimées maintenant. It's because at the end of the last page, Professor Pelé had expressed his frustration that the parties, including respondent, had not addressed orally the choice of forum argument, which had been put in the papers. And so the tribunal, the president requested that the parties deal with these two different arguments, fork in the road and the choice of forum objections. And it shows that the tribunal understood clearly that the Republic of Madagascar had made a global objection that all claims were subject to an irrevocable choice to go to the ICC. And the tribunal's description of the parties' positions in the award, including Madagascar's objection, bears out the fact that the tribunal had an accurate understanding of what the issues were. If we could go to the next slide, please. This is from the award, R340, paragraph 254. where the tribunal summarizes our position, which is laying out our position in response to the arguments, the objections by Madagascar, and clearly shows that the tribunal has the objection in mind. L'arbitrage CCI est distinct du présent arbitrage, selon nous. Ni les irrégularités procédurales substantielles commises par la Cour de cassation dans le pourvoi au fond, ni les griefs entourant la destruction de l'usine et l'absence de protection de l'État n'étaient soumis à l'arbitre CCI. That's one part of the sixth objection, which goes to everything including full protection and security. Et quant à l'introduction du pourvoi dans l'intérêt de la loi, les demandeurs estiment que l'article 12.3 laisse le libre choix à l'investisseur et que ce choix n'est pas irrévocable. D'ailleurs, Madagascar n'a pas fait état d'un préjudice découlant du choix de saisir le surdit. Those two last points about it not being an irrevocable choice, no prejudice arising from it, related to the denial of justice claim. The tribunal clearly summarized our position relating to both aspects of Madagascar's objection. And Madagascar's position itself is succinctly, sure, but accurately presented. And that's in paragraphs 251 to 252 of the award. Now, opposing counsel took you to paragraph 252 of the award during his presentation, but failed to show you the footnote 281 at the end of that paragraph. The tribunal in that footnote cross-referenced to the entire section of Respondent's memorial, laying out the two parts of its choice of forum objection. Yes, the tribunal did not recopy the paragraphs and paragraphs of the developments on that argument into the award. It cross-referenced into a footnote. If we can annul awards on that basis, with respect, we have a serious problem. Madagascar cannot demonstrate that the tribunal ignored its objection. To the contrary, it is beyond any possible doubt that the tribunal specifically referenced the argument. We can have a debate about the stylistic choices of tribunals, but there's no doubt that the essence of the objection is summarized in paragraph 254, and the tribunal was well aware of the full length and breadth of the argument. Madagascar's real complaint is much closer, as we have said, to an Article 52(1)(d) claim of a failure to state reasons. They did not make a claim that the tribunal failed to explain itself in enough detail. If they wanted to make that claim, they had to file a 52(1)(d) claim. They did not. They didn't, not because the same facts can lead to multiple grounds. They did that because they knew the argument would be doomed to failure. An annulment committee can always explain the awards if the explanation is too short or difficult to follow, if it is clear, implicit or obvious, what the reasoning behind the decision was. And here the reasons are absolutely clear. And I would just refer you to Soufraki versus the United Arab Emirates decision on annulment, which is DL 238 at paragraph 24 for that. Today, we heard opposing counsel say, well, if it were the other way around, we put it to the respondents in the annulment action that if the tribunal had just said jurisdiction denied, they would have also raised an excess of power claim. And they cited paragraph 56.2 of our duplique of our rebuttal to say that we said, yes, we would also have filed an excess of power claim. I encourage you to read Article 56.2 of the duplique. That was an exceedingly misleading summary of what we said. We did not say that. What we said is we would have filed an excess of power annulment action if we were convinced that the tribunal had made a mistake about its jurisdictional determination and that it had manifestly exceeded its authority in doing so. That's quite a different point here because it goes to the underlying question of jurisdiction. The next issue that Madagascar has raised is that, well, they combined, the tribunal messed it all up by combining the fork in the road and the choice of forum objections in one part of the award and should have treated them separately. The parties agree that that's what the tribunal did. It's in section 6B5 of the award. If we could go to that, please. There you'll see the plural, objection, plural, relative, plural, au principe du mode de règlement de différend. Maybe it's not the clearest way to deal with multiple objections in a single section, but it's a valid one, particularly where the underlying issue is the same. Are we faced with the same dispute in both or not? And the purpose of annulment, again, is not to review drafting choices in an award. The triple identity test that the tribunal spelled out in great detail on Fork in the Road is applicable to both clearly, and the tribunal dealt with both objections under the same heading. Obviously, the claim in Madagascar for payment on an insurance policy had no identity of parties, of rights claimed, or grounds, the triple identity. So the Fork in the Road was rejected. And equally obviously, the claims in the ICC proceeding, which related to the treatment of that insurance claim in local courts, did not have, if I take the French terms, les mêmes parties, objet de litige et cause. It's absolutely clear, and the tribunal understood, and it was understood from all the arguments, which were all referenced, that these were two entirely different claims. Full protection and security was not even mentioned in the ICC case. And on claim 2, also we argued, of course, that most of the manipulations of the legal system and the denial of justice were also after the ICC case. Madagascar's only objection here is that the tribunal, in its analysis, is that they say that although the ICSID dispute and domestic proceedings did not include the same parties, that consideration is inapplicable to the choice of forum objection because the ICC and ICSID arbitrations included the same parties. That's in the reply at footnote 85. Well, it's actually incorrect because the parties were not the same. PGM was a party to the ICC arbitration and not the ICSID proceedings, but more importantly, the claims and the basis of the claims were different between the two disputes. These were not the same dispute. Madagascar has absolutely no response on that point. And that is obviously what the tribunal considered by treating the two triple identity issues together in the same section of the award. With respect to the choice of forum argument relating to full protection security, the tribunal then clearly decided that when it stated, la compétence étant admise pour que le tribunal se prononce sur les violations alléguées, and that's the full protection and security claim. This paragraph shows that the tribunal did reject the choice of forum issue with respect to full protection and security. And having done that, it did not need to get to this subsidiary part about whether this choice of forum obligation argument applies to denial of justice. Now, the only reason, as I mentioned earlier, that Madagascar could get it in mind that this was a refusal to decide or a failure to decide is because they thought that the tribunal said that Madagascar had admitted jurisdiction, the tribunal's jurisdiction here. And that's clear from the memorial on annulment. Next slide, please, paragraph 6, where they say incorrectly, the tribunal asserted groundlessly that Madagascar had admitted to the existence of a jurisdictional basis that was in fact vigorously contested. Madagascar's thesis is based on a massively error of reading comprehension. The tribunal never said that Madagascar admitted its jurisdiction. The expression il est admis que means il est établi que. The root of the term admis is the same as admissible in English. The sentence means that the jurisdiction was accepted by the tribunal. En français, le sens voulu par le Madagascar aurait été le cas si le tribunal disait que le Madagascar avait été accepté sa compétence, ou la compétence du tribunal. Madagascar kind of half admits this massive error in the reply, paragraphs 51 and 52, where it says, I think it's the next slide, it's aware, so not on the screen, it's aware of the polysemy of the verb admettre, including in a legal context, and is attuned to the necessity of interpreting what the applicant and its counsel read. That, with respect, is a polysyllabic way of saying they were wrong in their reading of the award. Our interpretation of the award is not controversial, it's undeniable, and it's proven by the use of the same term admise elsewhere in the award, particularly paragraphs 331 and 365. This is just one example on the next slide, please, where the tribunal deals with it, but I'll move along. The tribunal well understood in paragraph 262 that it was deciding against Madagascar on one aspect of its jurisdictional objection about choice of forum, rendering the rest of it moot. Full protection and security was obviously not the same dispute that was in front of the ICC. The tribunal easily decided that la compétence est admise for that dispute. And because one element of the denial of justice claim had been in front of the ICC, the tribunal would treat that separately if it became necessary. And the tribunal repeated this in its decision, in its conclusion in paragraph 263. Could I have the 263? Could you go back 2 slides, please, Sean? And encore. Backwards, please. In paragraph 263, the tribunal thank you, concludes saying, le tribunal rejette les déclinatoires de compétences soulevées par la défenderesse. If there was any doubt whether in paragraph 262 it was rejecting the argument, that's taken care of in 263, and it's taken care of again in the dispositif at paragraph 482A, where the tribunal says, pour les motifs exposés ci-dessus, le tribunal se déclare compétent pour trancher le grief relatif à la protection et la sécurité constante. These are decisions. The question presented to the tribunal was decided. If Madagascar, by the way, thought really that the tribunal had failed to address a question that was presented to it, there is a quick and simple route to deal with that, which is Article 49.2 of the ICSID Convention. It specifically covers the ground, that ground, and on the request of a party, the tribunal may, and I quote, decide any question which it had omitted to decide in the award. Madagascar did not go that route because this argument is totally groundless, and instead it has taken the delaying route of filing an annulment action. In conclusion, there was no excessive power at all. The tribunal exercised its jurisdiction to decide its jurisdiction. It considered and summarily rejected Madagascar's frankly ridiculous argument that the FPS claim, for full protection and security claim, had been presented to an ICC tribunal already. To be clear, and then addressing some subparts of Madagascar's argument, the tribunal had no obligation to go into detail about all of the underlying arguments that Madagascar had put forward. The parties agree on this principle, just not on its application here. The flaw in Madagascar's argument is its thesis that while tribunals have to decide the claims submitted to them, here the claim that it didn't have jurisdiction because even the full protection and security claim was blocked by choice of forum, they don't need to address every single argument raised by the parties in developing those claims. And the application of this principle and the difference between that and an excess of powers has been explained pretty clearly in the Duke Energy annulment decision, which is on the left side of your screen. A tribunal does not manifestly exceed its power if it fails to deal with every argument raised by one party as to a legal question, as long as objectively it's dealt with the legal question itself. And the EDF International annulment decision deals with the same question on the right. And as we saw here, the tribunal did decide Madagascar's legal question, its objection. And the lack of a detailed analysis of that argument, of the various underlying arguments, does not support a claim for manifest excess of powers. Lacking any support, any jurisprudence, anything that would show that a failure to address an argument could result in an excess of powers, it tries to rely on decisions where a tribunal didn't give any reasons why it chose not to exercise jurisdiction that it had. So the best that Madagascar could come up with is DL 245 Orascom versus Argentina, but it was an entirely different situation there. In the Orascom case, the tribunal actually found that it had jurisdiction, but then refused to decide the claim, saying, well, the claim is inadmissible, without explaining why it was inadmissible. And there the committee decided, hey, you decided you have jurisdiction, you have to exercise your jurisdiction. But in this case, the tribunal said, we have jurisdiction, and it exercised its jurisdiction. It did what it was supposed to do. Finally, Madagascar tries to make a case out of an alleged failure to apply the proper law in deciding the decision, in making the decision under Article 12.3. So doubtless aware of the fact that the tribunal did really reject the first branch, the main argument in the sixth objection, the choice of forum, Madagascar has added an additional argument claiming that the tribunal exceeded its power by not applying the proper law. But that argument is just as unavailing. First of all, it's a very high standard to try and bring an excess of powers claim for a failure to apply law. As the AES Summit Generation Tribunal committee said in its decision in 2012, RL 273, the prevailing and correct view in modern investment jurisprudence must be understood as setting a very high threshold. Only a failure to exercise go to the next slide, please. Only a failure to apply the proper law in toto, as it was said in the AES versus Hungary annulment decision on the screen, can lead to a finding of an excess of powers. Partial application, not going down into the detail on one provision of the law, cannot suffice. And Madagascar cannot demonstrate that the tribunal failed to apply the proper law in its entirety. Madagascar takes issue with the fact that the tribunal did not provide its interpretation of Article 12.3 of the BIT. But the interpretation of Article 12.3 of the BIT was not the legal question that the tribunal had to answer. It just had to answer whether, after initiating the ICC arbitration on the basis of the pourvoi dans l'intérêt de la loi, our clients waived their right to bring an ICSID arbitration for a different claim. And the tribunal decided that question by rejecting the objections to jurisdiction. The tribunal, therefore, by finding that the same claim had not been submitted to two different arbitration tribunals, didn't need to get to the legal interpretation question. The only legal interpretation question would be, is the choice once made irrevocable? Can you, after an annulment, switch from ICC to ICSID? That question of the interpretation never became relevant in this case. So there was no excess of powers on any view, whether it be on the application of law or otherwise. And I'm going to turn the floor over to Ms. Grisol for the question of whether, even if there were some kind of potential excess of power, would it be manifest?
Monsieur le Président, Madame, Monsieur les membres du comité, Maître Strauve vient de vous démontrer qu'il n'y avait pas eu d'excès de pouvoir du tribunal. Donc, pour cette raison, et cette seule raison, la sentence ne devrait pas être annulée. Mais s'il vous reste un doute sur un potentiel excès de pouvoir du tribunal, ce n'est pas suffisant. La République de Madagascar doit vous convaincre d'un élément supplémentaire. Cet élément supplémentaire, c'est est-ce que cet excès de pouvoir est manifeste? Mais la République de Madagascar n'a pas démontré cela, bien au contraire. La théorie qu'elle vous présente, c'est la suivante. Le tribunal n'aurait pas pris de décision concernant son objection fondée sur un choix prétendument irrévocable à la CCI. Alors, comment savoir si cette prétendue omission du tribunal est manifeste? Beaucoup de comités ad hoc se sont penchés sur la question et on vous renvoie à nos écritures pour le détail de ces discussions. Mais ce qui ressort de toutes ces décisions, et c'est assez généralement accepté, c'est que vous pouvez interpréter le terme manifeste de deux façons, cumulative ou non. D'un côté, vous pouvez interpréter le terme manifeste comme étant un excès flagrant, clair ou évident en soi. C'est en fait le sens ordinaire du terme manifeste, et d'ailleurs, le Conseil de la République de Madagascar a insisté sur l'importance du sens ordinaire des mots quand il a défini sa notion de effective counsel. Et par ailleurs, un excès de pouvoir manifeste, ce serait un excès qui entraîne des conséquences sérieuses pour l'issue de l'affaire. En tout état de cause, c'est un standard très élevé et il faut que cet excès soit suffisamment grave. Ces critères, ils ont été récemment posés par une affaire qui a été citée par la République de Madagascar dans ses écritures et lors de sa plaidoirie. C'est l'affaire Perenco contre Équateur qui apparaît à l'écran. Je ne reviens pas dessus, mais les deux aspects de la définition sont exigés par le comité. Un excès flagrant et des conséquences sérieuses pour l'issue de l'affaire. Or ici, quelle que soit la définition que vous adoptez, est-ce que l'erreur est flagrante? Est-ce qu'elle entraîne des conséquences particulièrement graves? Rien de tout cela n'est caractérisé. En effet, et c'est mon premier point, si une erreur doit être manifeste, ça implique qu'elle exclut le débat. Il ne peut pas y avoir de doute sur l'erreur du tribunal. Et cette exigence, elle est très forte quand il s'agit de questions de compétences, notamment, en raison du principe fondamental selon lequel le tribunal est juge de sa propre compétence. Donc les comités, de manière générale, accordent une certaine confiance aux tribunaux quand il s'agit de statuer sur leurs propres compétences. Et cette confiance, elle a été témoignée, par exemple, dans l'affaire Frapport contre Philippines. C'est l'extrait qui apparaît à l'écran. C'est la pièce DL 262. The committee will not intervene where the tribunal's decision on its jurisdiction was not unreasonable. Et ici, il n'y a rien de flagrant. Il est loin d'être évident que le tribunal n'a pas pris de décision sur l'objection de la République de Madagascar. Maître Strauve vient de vous démontrer que c'est plus que débattu. Le tribunal a clairement rejeté tous les déclinatoires de compétences soulevés par la défenderesse. Et je vous rappelle ce passage de la sentence qui apparaît maintenant à l'écran. Le tribunal rejette les déclinatoires de compétences soulevés par la défenderesse. Et d'ailleurs, la République de Madagascar, Maître Strauve l'a rappelé, a elle-même reconnu que plusieurs lectures de la sentence étaient possibles lorsque le tribunal avait écrit « la compétence étant admise ». Et en tout état de cause, si vous considérez que l'excès n'est pas flagrant, si vous considérez que l'excès est flagrant, il faudrait toutefois qu'il entraîne des conséquences sérieuses pour l'issue de l'affaire, sans aucun doute. Or, là aussi, il y a plus qu'un simple doute, et même la République de Madagascar doute de ces conséquences sérieuses. Elle n'est incapable d'exprimer qu'il y a eu une conséquence grave à cette prétendue omission de statuer sur son objection. C'est ce qu'elle écrivait dans sa réplique, qui apparaît maintenant à l'écran. La République de Madagascar écrivait qu'en ne tranchant pas son objection, the tribunal possibly upheld a jurisdiction it did not possess. Possibly. Donc elle-même, elle n'en est pas sûre. Et il faut bien comprendre un point. Ce que vous dit la République de Madagascar, c'est pas que le tribunal, en admettant sa compétence, aurait commis une erreur manifeste, c'est qu'il aurait manifestement oublié de trancher cette question. Mais comme on vient de le voir, elle-même, elle n'est pas convaincue de cela. Et même s'il était flagrant que le tribunal avait omis de trancher cette question, il n'est absolument pas manifeste que l'objection, une fois tranchée, aurait eu un impact sur l'issue de l'affaire. Là encore, Maître Strauve vous a démontré que puisqu'il ne s'agissait pas du même différend, celui qui a été présenté à la CCI et celui qui a été présenté au tribunal CIRDI, la question de la protection et de la sécurité constante, il ne s'agissait pas du même différend. Donc la décision du tribunal est tout à fait, la décision du tribunal est tout à fait raisonnable. Or, pour pouvoir annuler une sentence, il faut être certain que le tribunal a excédé ses pouvoirs. C'est l'essence même de l'excès de pouvoir. Est-ce qu'il est allé au-delà? Est-ce qu'il s'est abstenu d'exercer ses pouvoirs? Et là, on peut faire référence à la décision qui a été rendue par le comité dans l'affaire Frapport. C'est aussi une décision qui est invoquée par Madagascar dans ses écritures, et c'est ce qui apparaît à l'écran. The excess of jurisdiction should be demonstrable and substantial and not doubtful. C'est la partie importante. Il ne faut pas avoir de doute sur cet excès de compétence. Et on vient de vous démontrer que le doute était bien là. Donc, même si le tribunal avait omis de trancher la question posée, il est impossible d'affirmer que cette omission aurait eu des conséquences sérieuses sur l'issue de l'instance. Donc, un éventuel excès de pouvoir ne serait pas manifeste. C'est pourtant ce qu'exige l'article 52.1b de la Convention CIRDI. Donc, la sentence ne peut pas être annulée. Et je vais maintenant laisser la parole à Théobald No sur le second moyen d'annulation. Je vous remercie.
Alors, est-ce que vous m'entendez? Oui, merci. Monsieur le Président, Madame, Monsieur les membres du comité, je vais maintenant répondre au deuxième moyen d'annulation qui est invoqué par la République de Madagascar, au visa de l'article 52.1d de la Convention CIRDI, selon lequel le tribunal aurait manqué d'observer deux règles fondamentales de procédure, soit un supposé droit à un effective counsel et le principe de la charge de la preuve. Alors, commençons par ce supposé droit à un effective counsel. Concrètement, que reproche la République de Madagascar au tribunal? Elle reproche au tribunal d'avoir constaté que la République de Madagascar aurait bénéficié d'une mauvaise représentation. C'est ce qu'on voit, Charles, au paragraphe 171 et 177 du mémoire en demande de la République de Madagascar. Et elle reproche au tribunal de ne pas être intervenu en fonction, soit de ne pas avoir demandé à ce conseil s'il avait l'intention de faire un travail plus sérieux et de présenter de nouvelles preuves ou arguments, c'est le paragraphe 168, mais également, elle lui reproche de ne pas s'être assuré que la République de Madagascar avait conscience des risques qui étaient associés à une mauvaise représentation par son conseil, c'est le paragraphe 173 du mémoire en demande. Il y a deux problèmes majeurs avec cet argumentaire. D'une part, le fondement factuel est faux, et d'autre part, la règle juridique invoquée par la République de Madagascar n'existe pas. Donc, premièrement, le fondement factuel. Pourquoi est-il faux? Il est faux parce que le tribunal n'a jamais constaté que le professeur Ben Hamida, qui représentait la République de Madagascar, aurait fait un travail qui n'était pas sérieux, un travail déficient. La République de Madagascar croit déceler cette critique dans la sentence, paragraphe 329 qui est à l'écran, lorsque le tribunal écrit « Madagascar aurait pu tenter de réfuter la description des faits de M. Rafanomen Soa, elle n'en a rien fait. » Il ne s'agit en aucun cas d'un jugement de valeur par le tribunal du travail de M. Ben Hamida. C'est une simple constatation. Il n'y a aucune preuve qui est produite par Madagascar. Et la raison sous-jacente est totalement étrangère au tribunal. Le tribunal ne sait pas si les preuves existent ou le tribunal ne sait pas s'il s'agit là d'un choix stratégique. Par exemple, ces preuves existent, mais elles étaient défavorables à la République de Madagascar, donc la République de Madagascar ne les produit pas. Nous l'avons établi dans le contre-mémoire. Et la République de Madagascar, c'est quand même marquant, n'a pas du tout répliqué sur ce point dans sa réplique. Elle n'a fait que refaire un renvoi à son argument dans le mémoire en demande. Donc, il n'y a nulle part dans la sentence une quelconque constatation que le tribunal aurait décelé une déficience du Conseil de Madagascar. En réalité, M. Ben Hamida, le professeur Ben Hamida, a fait un travail plus que sérieux. Il a produit des centaines de pages d'écriture, des centaines de pièces factuelles et des centaines d'autorités juridiques. Il a formulé 87 demandes dans sa requête de production de documents. Non seulement est-ce un travail qui est phénoménal, mais la République de Madagascar ne rapporte pas non plus la preuve qu'il y aurait eu un problème de qualité avec ce travail. À cet égard, la République de Madagascar fait plusieurs reproches à son ancien conseil. Donc, elle lui reproche, comme on l'a vu, de ne pas avoir produit de preuves pour réfuter la déclaration de M. Rafamen Soa. Elle lui reproche de n'avoir soumis aucune autre attestation de témoin ou d'expert. Elle lui reproche d'avoir fait un mauvais travail lors du contre-interrogatoire de M. Peter de Sutter. Et elle lui reproche de ne pas avoir été très convaincant au sujet de l'authenticité du contrat d'assurance entre la société PGM et Niavana. Le problème avec la position de la République de Madagascar dans ce recours en annulation, c'est qu'elle ne rapporte aucune preuve de ces éléments. Et c'est une accusation qui est extrêmement grave, qui est formulée là par la République de Madagascar à l'égard de son ancien conseil. En gros, elle l'accuse d'avoir été négligent. Elle sous-entend qu'il aurait eu accès à des preuves et qu'il aurait choisi par négligence de ne pas les produire. Mais où sont les preuves aujourd'hui de ces supposés témoignages qu'ils n'auraient pas produits par négligence? En réalité, la République de Madagascar vous demande de la croire sur parole. Alors, je ne vais pas passer ici un jugement sur la compétence de nos contradicteurs. S'ils ne produisent pas de telles preuves dans cette procédure d'annulation, c'est qu'elles n'existent tout simplement pas. Ce n'est pas qu'ils sont eux-mêmes négligents dans leur travail, tout comme le professeur Ben Hamida n'était certainement pas négligent dans son travail. Et d'ailleurs, même si la République de Madagascar estimait réellement que son conseil était déficient, il serait tout simplement impossible de démontrer que le tribunal avait, lui, en main les éléments du dossier qui lui auraient permis d'émettre un tel jugement de qualité. En effet, l'appréciation de la qualité du travail d'un conseil est très subjectif et le choix d'avancer tel ou tel argument est une question qui est éminemment stratégique pour tout conseil et dépend des éléments qu'il peut réunir et notamment de ses échanges avec son client. Alors, prétendre qu'un tribunal arbitral devrait s'immiscer dans ses choix, qu'il devrait faire valoir sa propre opinion sur la qualité du travail fourni par un conseil, sur ses choix stratégiques, alors qu'il n'a évidemment aucune connaissance du travail qui est réalisé pour réunir ces éléments, n'est évidemment pas sérieux. J'en viens à la deuxième partie de ma présentation, qui est que non seulement la critique qui est faite du tribunal par la République de Madagascar manque factuellement, mais que par ailleurs, l'obligation que la République de Madagascar cherche à imposer sur le tribunal au titre du droit à un effective counsel n'existe pas. On voit bien la difficulté qu'a la République de Madagascar à invoquer l'existence d'une telle règle. Selon elle, le droit à un effective counsel découlerait du droit de se faire représenter par un conseil, ce qu'elle appelle le right to counsel, et ce right to counsel serait accordé par la convention ICSID. Mais les pièces du puzzle ne s'assemblent pas. Pourquoi? Premièrement, parce qu'il n'existe pas de right to counsel dans le système ICSID tel que celui qui est invoqué par la République de Madagascar. Les affaires citées par la République de Madagascar où est reconnu un right to counsel sont des affaires qui sont rendues en droit interne, principalement en matière pénale, et qui concernent la désignation d'un avocat par l'État ou alors le droit à l'aide juridictionnelle, c'est-à-dire le droit de se faire représenter par un avocat qui est payé par l'État. Et bien sûr, un tel right to counsel n'existe pas dans le contexte CIRDI. Il n'y a pas d'avocat commis d'office et le CIRDI ne prévoit pas un système d'aide juridictionnelle. Le seul droit accordé par la Convention CIRDI est la liberté de se faire représenter ou non par un conseil. C'est l'article 18 de la Convention CIRDI. Ce n'est évidemment pas la même chose. Mais de plus, même lorsqu'un right to counsel existe, il n'implique aucunement un right to effective counsel dans le sens où l'entend la République de Madagascar. Sur ce point, les affaires mentionnées par la République de Madagascar dans ses écritures sont des décisions qui sont rendues principalement par la Cour européenne des droits de l'homme, sur le fondement de l'article 6 de la Convention européenne des droits de l'homme qui consacre le droit à un procès équitable. Et ces affaires sont rendues principalement en matière pénale et exceptionnellement en matière civile lorsqu'il existe de l'aide juridictionnelle ou que cette aide juridictionnelle n'existe pas, mais qu'il y a un cas flagrant d'impécuniosité d'une partie et l'absence de mise à disposition d'un conseil par l'État. Et sinon, la République de Madagascar, c'est encore des décisions des juridictions américaines qui sont rendues sur la base du 6e amendement de la Constitution qui assure en matière pénale un droit de représentation par un avocat, notamment l'affaire McCann contre Richardson, sur laquelle je vais revenir dans quelques instants. Principalement, que disent ces décisions? Elles disent que lorsque l'État met à la disposition des justiciables des avocats et qui sont ou devraient être payés par l'État pour assurer cette représentation, l'État a une obligation de s'assurer que la personne qui est désignée par elle est réellement présente pour son client et qu'elle est active. c'est-à-dire qu'elle se présente aux audiences, qu'elle ne dort pas, qu'elle n'oublie pas de se rendre présent. Je donne un exemple, car c'est l'exemple qui a été cité par mon contradicteur dans sa plaidoirie. C'est l'affaire Bertuzzi contre France de 2003, qui est la pièce RL 278. Vous avez entendu mon confrère dire il s'agit là d'une affaire dans laquelle la CEDH a conclu que le right to counsel implique une représentation concrète et effective. Et il dit il faut donc contrôler la qualité du travail qui est effectué par l'avocat. Mais de quoi s'agissait-il dans cette affaire? C'est un dossier où 3 avocats qui étaient désignés successivement ont dû se déporter car ils avaient des liens personnels avec le justiciable qu'ils étaient censés représenter. Et après que ces 3 avocats se sont désistés, le président du bureau de l'aide juridictionnelle n'a pas nommé de nouvel avocat. Donc, le justiciable n'a pas pu introduire un recours parce qu'il n'avait pas d'avocat. Et ce que la Convention européenne, ce que la Cour européenne des droits de l'homme a dit, c'est le droit à un conseil n'était pas réel, il existait sur le papier, mais concrètement, il n'a pas eu d'avocat, donc il y a une violation de ce principe. Mais la Cour européenne des droits de l'homme n'a jamais dit si l'avocat est présent, il faut que quelqu'un contrôle la qualité de son travail. Et d'ailleurs, comme le rappelle le guide de la Convention européenne des droits de l'homme sur le droit à un procès équitable qui est à l'écran, donc la pièce RL 260 au paragraphe 141, l'État n'est pas responsable des actes d'un avocat commis d'office. La conduite de la défense appartient pour l'essentiel au justiciable et à son avocat. La conduite de la défense en tant que telle, en dehors de certaines circonstances particulières, ne peut engager la responsabilité de l'État au titre de la Convention. Mon contradicteur a également évoqué l'affaire américaine McMahon contre Richardson de 1970. C'est la pièce DL 269. Et c'est l'unique exemple qui a été trouvé par la République de Madagascar, où il n'est pas simplement question de la réalité de la représentation dans le sens où quelqu'un est-il présent et visiblement actif, mais aussi de sa qualité. Cependant, cette affaire est rendue dans un contexte très spécifique. Comme toutes les autres affaires citées par la République de Madagascar, les affaires américaines, elle est rendue dans un contexte pénal. Et dans cette affaire, la Cour suprême dit « Defendants facing felony charges are entitled to the effective assistance of competent counsel ». Et dans cette affaire, comme on l'a expliqué dans nos écritures, le problème est qu'il s'agissait d'un plaidé coupable. Et la personne, le justiciable, n'avait pas été conseillé par son avocat sur les conséquences du plaidé coupable. Et dans ces circonstances très particulières, la Cour a remis en question la qualité du travail accompli par le Conseil. Mais c'est une affaire très spécifique qui n'a absolument aucun rapport, en dehors, qui n'a aucune conséquence, aucune conséquence en dehors du système judiciaire américain, qui, de par son propre texte, est limité à la cause pénale et donc qui n'a pas vocation à s'appliquer aux États-Unis en matière civile ou en matière commerciale. Et bien sûr, elle n'a pas à s'appliquer en arbitrage et encore moins en arbitrage CIRDI. Nous ne sommes pas ici en matière pénale, nous ne sommes pas dans un contexte d'assistance judiciaire. Pour conclure, les postulats de base de la République de Madagascar sont faux. Rien ne prouve que le Conseil de la République de Madagascar aurait fait un travail de mauvaise qualité, ni que ce serait la conclusion à laquelle le tribunal serait arrivé. Il n'existe pas de right to counsel au titre de la Convention CIRDI telle que l'entend la République de Madagascar. Et même dans les systèmes où il existe un right to counsel tel que l'entend la Madagascar, c'est-à-dire un droit à l'assistance judiciaire lorsqu'un justiciable n'a pas les moyens de se faire représenter, dans ces systèmes, il n'existe pas de right to effective counsel au sens où l'entend la République de Madagascar. Il n'y a pas de contrôle de la qualité du travail effectué par l'avocat. Dès lors, l'intégralité du raisonnement de la République de Madagascar devrait être rejetée car il est forcément basé sur un postulat erroné. Sur ce, je passe la main à Serena Salem qui va maintenant plaider les critères d'application de l'article 52.1d de la Convention CIRDI.
Bonjour, Monsieur le Président, Madame, Monsieur les membres du comité, est-ce que vous m'entendez bien? Oui, super. Donc, mon collègue vient de l'expliquer. Les postulats de base de la République de Madagascar sont erronés et tout le reste de son raisonnement est donc bancal. Aussi, le dossier de la République de Madagascar ne lui permet pas d'obtenir l'annulation de la sentence sur le fondement de l'article 52.1d de la Convention CIRDI, dont les 3 critères ne sont pas remplis. La République de Madagascar ne démontre pas que le right to effective counsel, s'il existait, serait une norme fondamentale de procédure. Il ne démontre pas de violation avérée et encore moins une violation grave de cette règle. Premièrement, sur le caractère fondamental de la règle de procédure invoquée. La République de Madagascar sait très bien qu'elle doit établir une connexion entre le right to effective counsel d'une part et la qualification de règle fondamentale de procédure d'autre part. Sinon, tout son argumentaire tombe. Elle propose 2 chemins pour y arriver, vous l'avez entendu. Elle nous dit que le right to effective counsel s'assimile au droit à être entendu, qui lui est une règle fondamentale de procédure et que donc par transitivité, le right to effective counsel devient une règle fondamentale de procédure. Elle plaide dans l'alternative que le right to effective counsel est une règle fondamentale de procédure à part entière. On va le voir tout de suite, aucune de ces approches ne fonctionne. Pour ce qui est de la première approche, il est vrai que le droit à être entendu est une règle fondamentale de procédure, ce n'est pas contesté. En revanche, il n'y a aucune assimilation qui est possible entre le right to effective counsel et le droit à être entendu. En effet, le droit à être entendu ne vise que l'opportunité donnée aux parties de présenter leur cas. La citation à l'écran illustre parfaitement ce propos. Maintenant, cette analyse, elle est concordante avec la jurisprudence. Nous sommes allés voir toutes les affaires CIRDI dans lesquelles il y a une reconnaissance de la violation du droit à être entendu. Et à chaque fois, c'était des situations dans lesquelles le tribunal n'avait pas donné l'opportunité aux parties de se prononcer sur un sujet, qu'il soit de fait ou de droit, qui ensuite a été important pour la décision et a impacté donc la sentence arbitrale. Je vous renvoie au paragraphe 22 de notre compte de mémoire qui liste ces affaires en détail. Maintenant, on a entendu la République de Madagascar tout à l'heure, elle ne le nie pas, et en réponse, elle dénature tout simplement les termes de l'affaire Wena comme elle l'avait déjà fait dans son dernier mémoire. Elle cite aussi les affaires Venezuela Holdings, la pièce RL 286, et Churchill Mining, la pièce DL 257. Certes, les termes qu'elle cite, adequate representation, full opportunity to present one's case, se trouvent bien dans les sentences qu'elle cite. Mais le problème, c'est ce que la République de Madagascar essaie de mettre derrière ces termes. Ils ne correspondent pas dans ces affaires-là à l'évaluation du caractère qualitatif de la représentation, qui est pourtant ce qu'elle met derrière son expression right to effective counsel, comme l'a rappelé mon collègue Théo Balnon. Dès lors, rien dans le droit à être entendu n'implique un jugement sur le caractère qualitatif. Donc, la République de Madagascar ne peut pas utiliser le droit à être entendu pour faire le lien entre son right to effective counsel et la qualification de règle fondamentale de procédure dont elle a besoin pour faire son argument. Maintenant, pour ce qui concerne l'approche consistant à faire du right to effective counsel une règle fondamentale de procédure à part entière. La République de Madagascar nous dit « Le right to effective counsel est un principe général du droit, et étant un principe général du droit, c'est donc une règle fondamentale de procédure au sens de l'article 52.1d de la Convention. » Ce raisonnement-là pêche aux 2 étapes. D'abord, ce n'est pas un principe général du droit. Les parties sont d'accord que pour identifier un principe général du droit, il faut d'abord montrer le caractère commun du principe visé dans les différents systèmes juridiques du monde. Or, on l'a dit, la République de Madagascar ne se réfère pas à un principe qui existe. Donc, évidemment, il ne peut pas être commun. Mais quand bien même on l'a suivi dans son raisonnement et on a accepté qu'en fait, ce sur quoi elle se fonde, c'est le principe de l'aide juridictionnelle. Eh bien, même si on le livrait à l'exercice de l'appréciation du caractère commun de l'aide juridictionnelle, on se rendrait bien compte qu'elle ne s'applique pas de manière uniforme. Comme l'a déjà dit mon confrère, l'aide juridictionnelle s'applique principalement en matière pénale et n'incombe en matière civile que dans des circonstances spécifiques, comme en matière de garde d'enfants, par exemple, dans un pays comme la Suisse. La CEDH a elle-même rappelé que, je cite, « There is no obligation under the Convention to make legal aid available for disputes in civil proceedings ». C'est notre pièce RL 261 au paragraphe 127, l'affaire Staros contre Pologne. Donc, le critère du caractère commun n'est pas rempli. Le deuxième critère pour apprécier la qualité de principe général du droit d'un principe, c'est de vérifier la compatibilité de ce principe avec d'autres principes fondamentaux déjà reconnus par le droit international. Là, ce que propose la République de Madagascar, c'est de créer un principe en vertu duquel les arbitres qui ne seraient pas convaincus par un argument ou une stratégie de défense interpelleraient une partie à travers ses représentants pour remettre en cause la qualité de la représentation de ses représentants. On voit bien que ça ne marcherait pas en pratique. Comme l'a déjà relevé Théobald, comment les arbitres sont-ils censés deviner si un argument ou une action procédurale réside d'une stratégie peu efficace ou bien d'une faille factuelle dans le dossier? En plus, ce right to effective counsel est complètement impossible à mettre en œuvre avec d'autres principes existants. Il présente un risque de fiction avec le principe du secret du délibéré. Il est impossible à mettre en œuvre sans contrevenir au principe de confidentialité des échanges avocat-client et il pourrait certainement créer une apparence de partialité et enfreindre le principe d'égalité des armes. Donc on voit bien que ce n'est pas un principe général du droit. L'autre partie de la proposition de Madagascar ne fonctionne pas non plus. Quand bien même c'était un principe général du droit, ça ne serait pas automatiquement une règle fondamentale de procédure. On l'a amplement expliqué dans nos écritures. Pour qu'une norme soit qualifiée de fondamentale, c'est encore plus difficile à prouver. Il faut, et c'est ce que nous dit le comité dans l'affaire Tenaris, notre CSBL 247, que la norme soit basic, invariable or absolute. Avec tout ce qu'on a déjà dit, on comprend bien que la norme de effective counsel ne remplit aucun de ces critères. Ce n'est donc pas une règle fondamentale de procédure dont on parle aujourd'hui. En plus de ça, le deuxième critère de l'article n'est pas rempli. Il n'y a eu aucune violation par le tribunal, que ce soit du right to effective counsel en tant qu'une émanation du droit à être entendu ou en tant qu'une règle autonome. La République de Madagascar a bien été entendue. Elle a eu amplement l'opportunité de produire ses arguments et de répondre à ceux du défendeur à l'annulation de manière équitable. Mon collègue l'a rappelé, elle a produit de volumineux mémoires. Le tribunal lui a même accordé dans son ordonnance de procédure numéro 6 1 heure additionnelle de temps de parole pour qu'elle puisse bien prendre le temps de contre-examiner l'expert ou le témoin de défendeur à l'annulation. Quant au compte-rendu de M. Rafa Nomé-Zantsoa, qu'elle reproche aujourd'hui au professeur Walid Ben Hamida de ne pas avoir réfuté en présentant de preuves contraires. La République de Madagascar a eu amplement l'occasion de les réfuter. Ils étaient dans le débat dès le début de la procédure. Ils ont été amplement discutés et les demandeurs à l'arbitrage, donc notre client rappelait déjà expressément que c'était à la République de Madagascar d'apporter la preuve contraire. Donc, on a déjà couvert ce point. Si la République de Madagascar n'a pas apporté de preuve contraire, la raison lui appartient. S'il n'y a pas eu de témoin, c'est peut-être parce que personne n'était prêt à témoigner en sa faveur. Le fait qu'il n'ait pas eu d'expert quantum est banal dès lors que son conseil a pu s'exprimer sur le contenu du rapport et contre-interroger d'experts, ce qui a été fait. En tout cas, ça ne traduit en aucun cas un manquement par le tribunal du droit à être entendu. Et si la République de Madagascar considère que son conseil a fait un mauvais travail, eh bien, c'est sa responsabilité à lui qui est potentiellement en cause et non pas celle du tribunal. Notre dernier point, et nous l'avons amplement démontré dans notre mémoire également, c'est que la sentence n'encourt l'annulation qu'en cas de violation grave. C'est-à-dire si la violation a amené à un résultat substantiellement différent de celui auquel on serait parvenu si la règle avait été observée. On a vu qu'il n'y avait pas de violation, a fortiori, il n'y a sûrement pas une violation grave. La République de Madagascar s'appuie sur une position minoritaire de la jurisprudence pour nous dire qu'il suffirait qu'une observation ait un impact potentiel sur l'affaire. Mais dans tous les cas, quel que soit le standard appliqué, il n'y a pas eu d'une observation grave. On revient sur les postulats de base que mon collègue a présentés. La République de Madagascar ne démontre pas dans cette procédure que si le tribunal était intervenu comme elle le souhaitait, le résultat, donc la sentence, aurait été substantiellement différente et même potentiellement différente. Comme l'a rappelé Théobald, la République de Madagascar n'a produit aucune preuve qui vous laisse aujourd'hui penser qu'il existait des moyens à la disposition de son conseil qu'il aurait omis d'invoquer ou de produire par négligence plutôt que par choix stratégique. En résumé, l'argumentaire de la République de Madagascar quant à la violation grave d'une règle fondamentale de procédure ne repose que sur des spéculations et des scénarios hypothétiques qui ne sont appuyés par aucune preuve tangible. La sentence ne saurait donc être annulée sur cette base. Très brièvement sur l'argument alternatif de la République de Madagascar fondé sur la violation de la charge de la preuve comme règle fondamentale de procédure. Il n'est pas sérieux. Selon la République de Madagascar, le tribunal arbitral aurait procédé à un renversement de la charge de la preuve. Or, la charge de la preuve sur une norme fondamentale de procédure et donc la sentence devrait être annulée. Comme nous l'avons expliqué dans nos écritures, l'argument ne tient pas pour deux raisons. Premièrement, le principe de la charge de la preuve, n'en déplaise à la République de Madagascar, n'est pas une norme fondamentale de procédure. C'est l'affaire Tenaris que nous avons retranscrite sur cette slide et qui est également dans notre mémoire, que je ne relirai pas. On a déjà répondu dans notre réplique aux arguments que la République de Madagascar a soulevés à cet égard encore dans sa plaidoirie de tout à l'heure au paragraphe 262 à 266 de la réplique auquel on vous renvoie. Deuxième raison pour laquelle l'argument ne tient pas, tout simplement, le principe a été respecté. Le principe de la charge de la preuve a été respecté. La République de Madagascar sait parfaitement comment fonctionne ce principe. Elle sait qu'il a été bien respecté. C'est vrai que les demandeurs à l'arbitrage ont produit le rapport du directeur de l'entreprise de gardiennage contemporain des fins sur les circonstances de la destruction de l'usine. C'était donc à la République de Madagascar d'apporter la preuve contraire, ce qu'elle n'a pas fait. Et c'est d'ailleurs ce que Madagascar reproche à son conseil. Elle lui reproche de ne pas avoir apporté cette preuve. Et elle écrit, et c'est la prochaine slide, elle écrit, c'est la deuxième citation, « At no juncture did the tribunal perform a minimum of due diligence to inquire whether Madagascar understood that it carried the burden to produce evidence challenging the respondent's evidence. » Donc c'est formidable, c'est la République de Madagascar elle-même qui, quelques paragraphes avant formulait son reproche sur le non-respect de la charge de la preuve, nous indique qu'en fait, admet explicitement en fait que c'était à Madagascar de supporter cette charge. La République de Madagascar ne peut donc sérieusement prétendre que le tribunal a renversé la charge de la preuve et la sentence ne saurait encourir l'annulation sur ce fondement non plus. Ça conclut notre présentation sur les différents points. Merci.
Merci beaucoup, Madame Salem. I think we now have in the schedule another short break before we hear the reply from the applicants. The reply is down, or the rebuttal it's called in the schedule is down for 10 minutes, I think, on my schedule. It's right to say, and this applies to both parties, that the committee, as you've seen, is not going to limit the parties within 10 minutes or so. By my watch, the respondent in annulment has just had a little over the hour originally scheduled. The applicants in annulment finished a little ahead of their hour, and certainly for my part, we're not going to limit the parties unduly. If Mr. Thoga and Professor Mbenge, you want to take a little more time than the 10 minutes foreseen, we won't be cutting you off. That's not an invitation to spend an hour, but understand it within reason. But I want to be clear to both of you that will apply equally to both of you. You must take the time to make the points you want to make to help us, because we're here for you. With that said, it is 3:29 in London. Shall we reconvene at 2:45? Does that make sense? So in 16 minutes. Very good. I see Mr. Ostrov, I see Professor Mbeng. I think we're all present. Are your team all present, Professor Mbeng?
Yes, yes, Mr. President, thank you. Everybody's present.
Mr. Ostrov, you content to proceed as well?
Thank you, Mr. President. We are
very good. Professor Mbeng, please, the floor is yours.
Thank you, Mr. President. Mr. President, dear members of the committee, I am here again for a few minutes so as to clarify a few details and confirm that there is no other way but to annul the award. Starting with the manifest excess of power, you may have been surprised, as Madagascar was, to see the respondents resuscitate the theory that the tribunal simply upheld its jurisdiction in general. And this was enough. This was sufficient. They refer again to the award's dispositive and say, see, the tribunal decided. In this respect, we stand by our reply and repeat that no, the tribunal could not just decide on its jurisdiction en bloc without deciding the objection specifically. This would let tribunals go too easily and deprive the ad hoc committee of any power to review if the tribunal addressed the questions that needed to be decided. It is not objectively reasonable to say that one can apply a triple identity test from one jurisdictional objection to the other when there is no identity of parties or object between the domestic proceedings and the ICC proceedings. Today's pleadings were useful in clarifying where the committee's reasoning need to focus. Since the tribunal was obliged to decide the questions before it, and since the objection was a question and not an argument, then everything hinges on whether the respondents' explanation of what the tribunal did, as found in their submissions, is convincing. Sadly, it is not. And the respondents have not tried to defend it today. They kept saying the tribunal could simply decide jurisdiction en bloc, and the award withstand annulment. That's their last line of defense, and it is ludicrous. Madagascar is, besides, very surprised by the emphasis put by the respondents in the rejoinder and today on the linguistic dispute around the word admis. To be sure, we stand by our reading of the award, but we showed in the reply that this was not only irrelevant, it only bolsters our case. The respondent's reading makes the excess of power even more striking. According to this reading, the tribunal just upheld its jurisdiction ex cathedra without addressing the objection and therefore without deciding it. This cannot be. Finally, we agree that the excess of power should be manifest, meaning flagrant, and with serious consequences. Mr. President, honorable members of the committee, what could be more flagrant than failing to decide an objection on jurisdiction? And what could have more serious consequences than upholding jurisdiction when it remains contested? It changes nothing that we agree the tribunal might have upheld it, possibly. Since the default general principle of law is that jurisdiction needs to be established, the tribunal needed to confirm its jurisdiction over the case. It could not leave it hanging in the air. What could have happened, a merits issue, is irrelevant here before the committee. Second, the serious departure from a fundamental rule of procedure. The respondents' pleadings did not deny the basics of this issue. The award does rely nearly exclusively on a single piece of evidence, and Madagascar's Council of Record failed to challenge or address it. Taken with the uncontested fact that the tribunal was the guardian of the integrity of the arbitration, this should be enough to recognize that something went truly wrong here, and that the award is fundamentally flawed. Maître Ostrov himself admitted that counsel for Madagascar was throwing smoke in mirrors instead of actually performing his duties. And yet, the respondents opted to fudge the issue in the hope of distracting from these uncontested facts. They contend that Madagascar's right to counsel does not include a right to effective counsel, which amounts to taking with one hand what they gave with the other. The respondents further contend that Madagascar counsel was effective, while the tribunal itself noted, for instance, at paragraph 329 of the award, the grave mistakes made by that counsel. Surely the tribunal knew better. Finally, the precarity of their defense was evident when they addressed the tribunal's reversal of the burden of proof. Either Madagascar's representation was adequate or it was not. We repeat that the respondents, despite all their efforts, cannot have it both ways. Finally, allow me, Mr. President, a few words as to the most extraordinary contention found in the respondent's rejoinder, but not repeated at the hearing, that the committee should exercise discretion and refrain from annulling the award, even if Madagascar is right on the merits of the annulment application. First, it shows the weaknesses of the respondent's case, if they need to rely on this alleged discretion. Second, it is patent that the sole example they adduce as precedent does not support their case. Their own quote from the decision in Vivendi at paragraph 135 of the rejoinder confirms that the Vivendi committee has come to the conclusion that there is no sufficient ground to annul the second award. And finally, the alleged principle that disputes should come to an end cannot be allowed to defeat Madagascar's treaty right to seek annulment of the ICSID award, especially since this award threatens the integrity of the system by leaving jurisdictional issues in the air. Mr. President, dear members of the committee, these annulment proceedings are not about Professor Ben Hamida. These annulment proceedings are not about the tribunal. These are people, colleagues, friends that we respect. As Maître Kristof said, very brilliant lawyers. But these are also human beings, and human beings make mistakes. The best lawyers, the most esteemed lawyers can still make mistakes. And this is what has happened in this arbitration. These annulment proceedings are about the integrity of the system. It should now be clear that the award cannot stand. First, because it sanctions a manifest excess of powers. You have heard today a number of theories as to what the tribunal did or rather did not do with respect to the choice of forum objection. These theories are incompatible, and their very number evidence that any good faith reader would find the award incomprehensible. Today's pleadings only serve to demonstrate what I said earlier in French. No one can say how, and above all, whether the tribunal dealt with the choice of forum objection. As a result, no one knows if the tribunal truly had jurisdiction. The award cannot stand. Second, because it results from a serious departure from a fundamental rule of procedure. My colleague, Mr. Ehrenstoger, has demonstrated the flaws in the respondent's approach to the issue, be it on the law or on the facts. What remains is that the award before you is not the result of a debate fought with equal arms, but the consequence of a fundamental flaw in Madagascar's defense. That flaw, the tribunal should have prevented it. It was its duty as the guardian, once again, of the integrity of the arbitration. And yet that flaw has been allowed to mar the award by letting it stand solely on the weakest and most unchallenged piece of evidence. I understand that the committee's task in this matter is not easy. We are indeed dealing in the second award in a long-hold dispute. Everyone is unsatisfied by the way things have turned out. And no wonder, since the parties were entitled to see the dispute settled once and for all. Madagascar asks you to acknowledge the sad yet obvious fact that the tribunal committed 2 grave mistakes. This is not easy. As to the respondents, it is fully understandable that they came to the rescue of an award that, flawed as it is, remains favorable to them. Today's hearing proved once again that they strove to do so. And yet, these flaws cannot be ignored. Contrary to what we heard again today, it is not gladly that Madagascar filed for annulment of the award and is now insisting on its right to challenge it. It is not to annoy the Sutter brothers or to delay anything. It is because the integrity of the ICSID system is at stake. When Madagascar agreed to arbitrate in the ICSID context, this was because it felt confident that this system was robust and would not turn a blind eye to such fundamental errors. It is not Madagascar's fault that the original ICC proceedings were annulled. The committee task is once again not easy, I said, but the choice before it is. The award can stand or fall, but if it stands, it would be on the basis of a manifest excess of powers and a serious departure from a fundamental rule of procedure. Awards with that kind of flaws are not meant to withstand annulment. If this one does, states and investors around the world would lose all assurances that ICSID tribunals will rightly answer all questions before them and that their procedural rights will be safeguarded. Mr. Ostrov asked in opening, what should the Sutter brothers think of international justice? Well, with all due respect, they should think that it is working as expected and is not meant to favor one side or the other. This is what Madagascar means by the integrity of the system, and there is no contest that it should be protected. Mr. President, dear members of the committee, thank you very much for your attention.
Thank you very much, Professor Mbengue. I assume we're not going to hear from Mr. Stoger at this stage, and that concludes your rebuttal.
Yes, Mr. President, I'm sorry for that. This concludes our rebuttal. Thank you very much.
Oh, not at all. I just wanted to check for certainty. Then we take the next 15-minute break. We'll come back at 4:15 London time, 4:15 the hour, whatever the time is, wherever you are, for your rebuttal, Mr. Ostrov. Thank you all.
Thank you.
I think all participants are back. If I look at the participant list, see Professor Mbengue and Mr. Stoger. So, Mr. Ostrov, if you're ready, please proceed.
Thank you very much, Mr. President. I'd like to first come back on one point made in the oral argument by Madagascar, and then a few points made on the rebuttal that we just heard. With respect to the main argument, one of the arguments that they made is that the tribunal they don't like the tribunal's treatment of the evidence. And they argue that we did not, in the underlying arbitration, properly carry our burden of proving the responsibility of Madagascar for the destruction of the factory, because our main evidence were numerous contemporaneous reports of the Director of Security. And actually, there was a bit of a misleading reference to that evidence saying, unfortunately, the Director of Security was not able to attend the hearing, making it sound like there was just a difficulty getting witness there. But yes, unfortunately, the Director of Security had died 5 years before the hearing, and therefore it was absolutely impossible to get him to appear as a witness. And the tribunal dealt with that question in weighing, saying he's not a witness, this is contemporaneous evidence, we are going to weigh that evidence. And what I would say is that it is not for an ad hoc committee to replace the discretion of an arbitration tribunal with respect to the weighing of evidence. But that's not me saying that. That's paragraph 193 of the memorial on annulment. That is Madagascar admitting that that is not a proper basis for an annulment. The question of how the evidence went is simply out of bounds for an annulment action. With respect to a few of the points that we just heard on rebuttal, Madagascar, Professor Menge claims that when I referred to the dispositif of the award, paragraph 482A, it was an admission on our part that the tribunal decided jurisdiction en bloc, just said, we have jurisdiction over this case. That is absolutely untrue. The dispositif, paragraph 482A says, pour les motifs exposés ci-dessus, le tribunal se déclare compétent pour trancher le grief relatif à la protection et la sécurité constante. In other words, the tribunal specifically rejected the specific branch of the sixth objection to jurisdiction. The jurisdiction over the full protection and security claim was the subject. It was one specific question of Madagascar, was the fact that the ICC arbitration had been brought before. Did that bar us from bringing the full protection and security claim to the ICSID tribunal? And very clearly, I will not repeat myself, that was simply not a claim that had ever been brought anywhere before, and it was that specific objection that was rejected. But I would point out that it's actually worse than that. It was so obvious to the tribunal. Why? Because if you actually look at paragraph 356 of the award, you'll notice that the tribunal also rejected another argument by Madagascar, which was that we could not bring the full protection and security claim because we had never brought it before, and it was time barred. So they're making two completely contradictory arguments. On the one hand, saying, you have never raised this claim before. This is an entirely new dispute, and it's time barred because the statute of limitations in Madagascar is X years. And the tribunal rejected that claim, saying, no, there is no time bar for an international claim like this and in these circumstances. So it is just beyond any shadow of a doubt that the tribunal understood, and Madagascar understood, that the full protection and security claim had never been brought any place before, and therefore the argument that there was some kind of choice of forum irrevocably made with respect to that claim had to be rejected. Which leads me to my next really overarching point with respect to the rebuttal that we just heard, which is Madagascar complains that we have argued to you in writing and orally that the tribunal actually had jurisdiction over the full protection and security claim, that we've gone into the merits of that argument. Well, with respect, Madagascar has not responded at all on the merits of that argument. They have never said to you in writing or orally that in fact, the tribunal did not have jurisdiction over the full protection and security claim. They've not explained to you why that could possibly be the case. And that goes directly to what we just heard, where we heard Professor Mbenge argue that what could be more flagrant, what could be more manifest than failing to decide a jurisdictional issue okay, well, we've already pointed out the jurisdictional question was decided. And he said, what could be more important than leaving jurisdictional issues in the air? Well, that's actually not what it means for there to be a manifest excess of powers. It doesn't mean that there's an undecided, uncertain jurisdictional issue floating around. What they would have to prove is not only that it wasn't decided, but that it would have such serious consequences because the tribunal did not have jurisdiction. The tribunal exercised a jurisdiction that manifestly it did not have. They have not even attempted to bear that burden. Whereas here, as we've already explained, it is manifestly obvious that the tribunal had that jurisdiction because the claim had never been raised elsewhere. Now, on rebuttal, we were a little surprised to hear in this connection a rebuttal to an argument we didn't make during our oral argument to you today. In fact, Professor Mbenge pointed out, interesting that respondents to the annulment action did not come back on a point that they made in their briefing, that you as a committee have a discretion to annul or not to annul. If you find technically the capability to annul, you don't have to use that. And it's true, we didn't plead that orally. It's a point that's in our briefing. We didn't want to spend our time on that. That's fine. But it goes precisely to this point. If you were somehow persuaded that the tribunal in fact did not decide the question presented to it and did not decide this jurisdictional issue, and therefore was leaving a jurisdictional issue hanging, and if you decided that that in and of itself is grounds to annul an award, even though the tribunal, there's no evidence, there's no proof, there's no reason to think the tribunal did not have jurisdiction, you should absolutely exercise your discretion not to annul the award, because what would happen if you annulled the award? Messrs. de Sutter would have to go back and start an arbitration again on the full protection and security claim, saying to the tribunal, please decide that you have jurisdiction over this case because it just simply wasn't decided last time. And obviously this claim had never been raised before. And the whole reason that there's some discretion there is to avoid some kind of technical ground for annulment where there's really no systemic reason to do that. We didn't bother raising that earlier today because we don't think this case comes anywhere near a situation where there's actually something annullable where you should not have to, where you should have to exercise the discretion not to annul. But I just want to make clear that our position on that was misrepresented, and systemically it's actually an important point. That's all we have. So thank you very much for your attention, and we look forward to answering any questions that you might have.
Thank you very much, Mr. Ostrove. Why don't we take another short break, then the 15-minute break for the tribunal to discuss and formulate any, the committee to discuss and formulate any questions it may have, and then we'll come back at 22. Very good. See you soon.
Thank you.
Very good. I think that's everybody back. The tribunal does have a few questions for the parties, and I'll ask my colleague, Ms. Van Leeuwen, to begin, please.
Thank you, Dr. Harris. I have a question to the applicant in annulment, to Professor Mbengue. We have heard the argument on behalf of the respondents in the annulment. They pointed out that Madagascar did not avail itself of the possibility under Article 49 sub 2 of the ICSID Convention to apply for a rectification decision. I don't think that this issue has been covered in the presentation of the applicant in annulment today. And I would like to have on record the position of Madagascar in light of its assertion that the tribunal did not decide one of its jurisdictional objections at all. So the question is, would it not have been incumbent on Madagascar to apply for a decision under Article 49.2 of the ICSID Convention?
Mr. President, should I respond?
Apologies, yes, please.
Thank you, Mr. President, and thank you very much, Madam Van Leeuwen, for your question. The reason why we did not address this argument regarding Article 49, paragraph 2 is, as we have indicated at the very beginning of the hearing today, that Madagascar reiterates all its arguments and confirms all the positions it has formulated in its written submissions. And we have addressed the issue of Article 49.2 of the ICSID Convention in our reply, in particular from paragraph 80 to paragraph 88 of the reply. And what I can say in just to sum up what we said there is that the established and constant jurisprudence of ICSID tribunals actually show that Article 49 is not a prerequisite to go before an annulment committee. I do not think that the ICSID Convention puts in place a system where you need to exhaust some sort of remedies before you can use some others. Maybe the only one would be the relationship between, of course, an award and an annulment committee. But in between, there is no requirement to follow a certain order before you can come to an annulment committee. This would be contrary to the object and purpose, to the ordinary meaning, and any interpretation in good faith of the ICSID Convention. So to put it very simply, Madagascar doesn't believe that the right remedy, the appropriate remedy, was an Article 49, paragraph 2 avenue. And the reason is very simple. It's because what we wanted to invoke as grounds were grounds of annulment. And for this reason, Article 49, paragraph 2 was not the proper avenue. But once again, I would like to kindly bring your attention to our analysis in the reply, where we actually show that jurisprudence constant in the ICSID system tends to not accept this idea that Article 49.2 might be a better remedy than annulment under Article 52. Thank you very much, Madam Leeuwen. Van Leeuwen, sorry.
Thank you, Professor Mbengue.
Is there anything else that you want to ask, Ms. Van Leeuwen?
Not for the moment.
Dr. Bottini, do you have any questions?
Yes, thank you very much. For Professor Menge, it's the first question. Professeur, je voudrais mieux comprendre l'avis de la République de Madagascar sur l'objection de juridiction, en particulier sur les choix en vertu de l'article 12.3 du TBI. Et ma question, ceci, ces choix est-il définitif, même concernant un autre différend? Ça, c'est ma première question pour vous.
Merci beaucoup, Monsieur Bottini, pour votre question. Et je pense que ça nous permet de rebondir sur un point très important. La position de la République de Madagascar consiste à dire que l'article 12, paragraphe 3 du BIT n'a pas fait l'objet d'interprétation et d'application par le tribunal. Et justement, la raison pour laquelle on conteste le fait que le tribunal ait décidé de la compétence, c'est qu'il aurait été impossible de décider de la compétence sans procéder à une interprétation de l'article 12.3 pour se poser la question, qui est la question que vous venez de soulever, quelles sont les implications en vertu de l'article 12.3 du TBI? Est-ce que l'article 12.3 empêche de changer de forum après qu'un forum a été initié? Et si oui, quelles sont les conditions? Et sinon, quelles sont les conditions qui empêcheraient justement de changer de forum après qu'un forum ait été initié, même si le différend n'est pas le même en tant que tel, même s'il y a des objets ou une cause qui sont différents. Le tribunal, et là, ça nous permet vraiment de remettre l'accent sur ce problème. Le tribunal n'a même pas fait l'effort, en quelque sorte, d'interpréter sa compétence en vertu de l'article 12.3. Et donc, la raison pour laquelle Madagascar dit que la compétence n'a pas été décidée, c'est parce qu'on ne peut pas décider une compétence si on ne l'établit pas. Et on ne peut pas établir une compétence si on ne procède pas à l'interprétation du titre de compétence en tant que tel. Et donc, je pourrais vous donner notre opinion sur l'article 12.3, mais je pense que ce n'est pas là le rôle du comité que de servir comme cour d'appel, puisque le rôle d'un comité d'annulation est de vérifier s'il y a eu légitimité dans le processus, et le tribunal, en n'ayant pas procédé à une interprétation en vertu des règles coutumières du droit international public de ce que signifie l'article 12.3, a manqué à son obligation en matière d'établissement de sa compétence. Voilà ce que je peux répondre pour cette question, M. Bottini. Merci.
Merci, professeur. La dernière question pour vous, c'est, vous avez bien souligné que le tribunal, dans l'ordonnance de procédure numéro 3, le tribunal dit qu'à première vue, l'arbitrage CCI et le présent arbitrage portent sur des objets différents. Et ma question ici, c'est cette opinion du tribunal, est-ce que ça c'est suffisant pour être la base d'une décision juridictionnelle du tribunal?
Merci beaucoup, M. Bottini. Écoutez, la position de la République de Madagascar, c'est qu'on ne saurait utiliser des procédures incidentes telles qu'une décision une ordonnance sur la bifurcation pour préjuger d'une question aussi importante que la compétence. Une ordonnance de procédure sur la bifurcation, la question qui se pose dans une telle ordonnance, c'est faut-il bifurquer ou non? Mais l'objectif, l'objet et le but d'une ordonnance de procédure en bifurcation n'est pas de déterminer de manière finale, de manière définitive, la question de la compétence. Et c'est la raison pour laquelle, dans notre exposé un peu plus tôt cet après-midi, nous insistions pour dire que si l'ordonnance de procédure avait eu véritablement pour objet de décider de la question de la compétence, alors Madagascar se serait opposé à cette ordonnance de procédure, puisque ce n'est pas là la fonction d'une ordonnance de procédure, notamment en bifurcation, puisque la raison de la bifurcation, c'est justement de soulever des questions de compétences. Et là, un tribunal a le choix soit de bifurquer pour décider des questions de compétences, soit de joindre les questions de compétences au fond, mais le résultat est le même. Quelle que soit l'avenue qu'on prend, on ne peut pas décider de manière définitive, et je dirais même pas prima facie, la question de la compétence. Donc, l'ordonnance de bifurcation, contrairement à ce que prétendent les défendeurs, ne peuvent pas servir à dire que le tribunal a décidé. Oui, ça peut peut-être servir à dire que le tribunal a compris. Le tribunal a certes compris qu'il y avait une objection à la compétence, mais le tribunal, la compréhension ne signifie pas la décision. Et donc, une ordonnance de bifurcation ne peut sûrement pas être invoquée pour établir la compétence, quel que soit ce qui a été dit dans cette ordonnance, ça ne saurait préjuger d'une décision finale sur la compétence qui n'a jamais été prise par le tribunal. Je vous remercie, M. Bottini.
Merci beaucoup. I would like first to give the chance to the respondent annulment to comment on the points that Professor Menge just made. If you have any comments, Mr. Ostrov.
Thank you very much, Mr. Bottini. With respect to your first question, I would note that with everything that was said, you did not get a response to your question. As we pointed out earlier, the applicant here has never furnished an explanation as to why, under Article 12.3 of the treaty, a different dispute could possibly be tied to an earlier decision of a choice of forum. It doesn't really require any interpretive exercise. Article 12.1 says every dispute, tout différent, can be dealt with in a certain way. Article 3 then says, en cas de recours à l'arbitrage international, le différent sera soumis à. So Articles 12.1, 12.2, and 12.3 are all talking about le différent. And here we have a different différent, and you've had no explanation from the applicant in the annulment as to how possibly their argument could be carried through. And then with respect to your second question, we agree. Of course, the tribunal could not prejudge at the stage of bifurcation the decision. It was not fully submitted yet. But what's clear is that the tribunal gave a strong indication prima facie, and there was nothing ever submitted in the record that would undermine that. So when the tribunal says at the end that it rejects the jurisdictional objection with respect to full protection and security, and when it says that sa compétence est admise for full protection and security, and it does that in the same section that it has combined on a triple identity test, after laying out the arguments that have been presented, that we just submit that there's no doubt that the issue that it raised prima facie at the bifurcation stage has clearly been accepted by it and decided in the award. Thank you.
I guess probably my last question really follows up with what you just said, Mr. Ostrov, because my point then would be, where can we find in the award that analysis, right? The distinction between the dispute before the ICC tribunal and the dispute before the ICSID tribunal. I guess one can refer to paragraphs 258 to 260, making that a distinction as regards the contractual dispute, but where can we find that distinction between, again, the ICC dispute and the ICSID dispute?
And the place to find it essentially is where the tribunal has stated what our position was at the time, where it restated and summarized our argument on all of those points. And then after pointing out the triple identity with respect to Madagascar, the Madagascar claim versus the claim here, it then simply decides. So the only place that you'll find the actual argument is in our position, but then the tribunal, in deciding to reject Madagascar's position, has clearly accepted our position. So the reasoning is, in our view, clear, implicit, reflected in the summary of our position. And we can accept that the motivation could have been more clearly and explicitly laid out, but that's not a claim that's in front of you, which is a défaut de motivation, a lack of motivation, which is a separate heading for annulment.
Thank you very much.
Thank you. Just out of an abundance of caution, Mr. Ostrov, was there anything you wanted to say? You obviously have the right to say anything you want in response to the first point that Professor Mbenge made in relation to Article 49.2 and Ms. Van Leeuwen's question. I don't know if there is anything you want to say on that topic.
Thank you, Mr. President. No, we think that our position on that is set out in our counter memorial and referred to in our rebuttal. And there's just when I clerked for a federal judge, every time each party would cite jurisprudence to him and each say this means that and the other says the other thing, he would look down at everyone and say, well, I guess this means I'm going to have to read the cases. So our submission to you is it's fully submitted, or you have opposite positions as to whether that's a requirement in the system. And in our view, as it is clear for the French Cour de Cassation, it's also clear in ICSID that there's a specific remedy for this issue that they've raised. And if you don't avail yourself of that specific remedy, you shouldn't be going on then to the more violent remedy of annulment.
So you're maintaining the position that it actually precludes the entire annulment proceeding?
Absolutely, yes.
Yes. I have two questions for the parties. The first question is this: if one looks at paragraph 262 of the award that we've all become very familiar with, and the line that is particularly debated by the parties in their briefs, la compétence étant admise pour que le tribunal se prononce sur les violations alléguées en lien avec le pillage et la destruction de l'usine. That first part of that sentence, the tribunal has noted that if one turns to paragraph 237 of the award, where the tribunal was dealing with the question of whether there was a dispute in relation to, in direct relation with an investment for the purposes of Article 25(1) of the Convention. If Mr. Gorel can scroll up slightly, we'll see the heading of analyse. This is the tribunal's reasoning on that question. And in that paragraph 237, the tribunal is dealing with this question about particularly the dispute in relation to pillage et à la destruction de l'usine. And the committee just wondered if the parties had any view on whether the reference in 262 to the la compétence étant admise might be a reference back to this decision in paragraph 237, confirmed in paragraph 239. Professor Mbenge, I asked you the question first, and then Mr. Ostrov, you and your team, you or another member of your team can comment afterwards.
Thank you very much, Mr. President, for the question. The position of the Republic of Madagascar is that jurisdiction under the ICSID Convention is a double keyhole based process. So you have, of course, the provision under the convention, which is Article 25, paragraph 1, that the dispute needs to relate needs to be in relation to an investment. But this is not sufficient to establish jurisdiction under the ICSID convention, because the ICSID convention doesn't give, is not by itself consent to jurisdiction. We know that states that ratify the ICSID convention do not automatically have consented to ICSID jurisdiction or to the jurisdiction of an ICSID tribunal. You always need an additional title of jurisdiction, and here the additional title of jurisdiction is Article 12, paragraph 3 of the BIT. So we cannot deduce from 207 that, you know, when the tribunal says la compétence étant admise in 262, that this was solved by 237. That would be another illustration of what we call a mistake in dealing with jurisdiction. 25.1 is not enough. So the reasoning under 12.3, and in light of the objection that was raised, what we call l'objection principale by Madagascar, should have been dealt with. And so there is a missing link. There is a missing link. We have 25.1. Let's assume that what is said in paragraph 237 is about jurisdiction, but then you have a missing link, and suddenly you have 262 that is saying la compétence étant admise. How was it established in between? That's the problem. Thank you very much, Mr. President.
Thank you. Mr. Ostrov.
Thank you. You'll actually have some agreement between the parties on this point, I'm happy to tell you, which is we agree that the statement la compétence étant admise with respect to the pillage, with respect to full protection and security, is not a reference back to the analysis in part 3B in paragraph 237, because that was a different jurisdictional question, and it was making in paragraph 237, it's making its analysis on that jurisdictional objection, and in paragraph 262, the tribunal is making its decision that la compétence étant admise for the question of full protection and security is making the decision on the choice of forum. The only thing I would say is, as we've said, the decisions based, the reasoning behind that is implicit and is evident from, we pointed out the arguments, the referral to our arguments on it, but paragraph 237 is yet another place in the award where the tribunal makes it very clear that these are completely separate disputes, the ones relating to the litigation about the insurance policy, and the one that's a direct responsibility of the state for failure of full protection and security. Thank you.
Finally, I just have a question for you, Mr. Ostrov. You talked briefly in rebuttal about the position in relation to the discretion to annul or not annul. What I was curious about was in what circumstances do you say that it would be appropriate for a committee to exercise its discretion not to annul an award, having found that one of the narrow grounds for annulment, as you both agree, in Article 52 is made out? Because it can't simply be that it would be unfair to require a party to go back around again, otherwise, because that could potentially apply in every case. So I just wondered if that was something that you had any thoughts on.
So it would be it would clearly be relatively rare that would happen. An example would be a fundamental rule of procedure where for a witness was not allowed to be heard, a party was not allowed to take a position on something, and that was a violation of a fundamental rule of procedure. But in fact, that violation has no impact, no outcome on the award. So you'd say, well, are we going to sanction the tribunal? Where we're going to say, yes, there's a violation of a fundamental rule of procedure here. That gives us the authority to annul under Article 52, but in fact, that violation had no impact, no decisive impact on the outcome of the case. So if we then annul simply because there was a technical problem, that doesn't serve any justice, doesn't serve the interests of the ICSID system. And similarly, please, my apologies if I'm repeating myself, if ever you had an interpretation that the tribunal committed an excess of power by deciding the question submitted without detailing the arguments that supported it, that there was actually a different claim being made in the ICSID case than in the ICC case. Similarly, it doesn't serve any purpose to annul the award. It slaps down the tribunal for having not explained itself, but on a point where it's sorry to use a US basketball reference, no harm, no foul. There's no way the tribunal did not have jurisdiction for the point. So if you then go ahead and annul because of the procedural way they handled it, when in fact it made no difference in the underlying case, then that's another area where you should exercise your jurisdiction, your discretion. But to be very clear, that is a extremely subsidiary argument for us because obviously you have our principal submissions.
Professor Mbenge, is there anything you want to say on that point?
Yes, thank you. Thank you very much, Mr. President. I think that your question actually brings us back to Madame Van Leuven's question, and I think that the response that has been just offered now to us by Council of Respondents is showing a confusion between Article 49.2 and Article 52 of the ICSID Convention. Article 49.2 is about correcting mistakes. Article 52 is about the integrity of the system, the integrity of ICSID proceedings. What Maître Ostrov has just presented now is a scenario saying, okay, if you annul, it does not really help because at the end of the day, the solution would be the same, meaning these are just small mistakes that a tribunal could correct under Article 49, paragraph 2. But the Republic of Madagascar is of the view that what has happened in this arbitration is not just about small mistakes that could be corrected under Article 49.2 or that would not lead anyways to a different solution. We have real jurisdictional objections that have been raised. And there is one particular objection that has been raised by Madagascar under Article 12, paragraph 3 of the BIT. I do not think that it is for us here or for the committee to second guess what would have been the outcome. It is jurisprudence constant of ad hoc committees that ad hoc committees are not appeal mechanisms. They are not here to review the law or second guess what should have been the best interpretation of the law. They are here to preserve the legitimacy of the proceedings within the ICSID arbitration system. So I think that we really disagree with all respect when respondents keep on saying that we have never said what would be the real outcome or what would be the real interpretation or the correct one or what would be a serious consequence. The fact that jurisdiction was admitted without establishing it in accordance with customary rules of treaty interpretation, in accordance with general principles applicable to international courts and tribunals, is a flaw that deserves to annul the award. The rest is beyond the mandate of an annulment committee. Thank you very much, Mr. President.
Thank you very much, Professor
Dr. Harrod, can I ask one follow-up question of Professor Mbenge in that respect?
Of course, of course.
Professor Mbenge, you refer to small mistakes that can be corrected under Article 49.2, but 49.2 also specifically identifies that any question which it had omitted to decide in the award, that can be rectified. And you say this jurisdictional objection has not been considered at all by the tribunal. So wouldn't that be a case of the omission that Article 49.2 provides for?
Thank you very much, Madam Van Leuven. I think that when we look at the rather constant and general practice of both states and investors under the ICSID system, when they believe that a tribunal has made a fundamental error in the treatment of the questions, they do not have recourse to Article 49, paragraph 2. And I think that this is something that needs to guide the interpretation or the position that will be retained by the committee. The practice of the community of investment in the ICSID system, when both states and investors believe that an award has been affected by a fundamental error, is to go to have recourse to annulment under Article 52, because once again, these type of mistakes or omissions, I agree that 49.2 covers also omissions, but some of the omissions, some of the mistakes, they touch deeply upon the arbitral function, Article 49, paragraph 2 is not about the integrity of the arbitral function. Article 52 is about, and the reason why Madagascar chose to have recourse to annulment under Article 52 is that we believe that what has happened in these proceedings touch upon the integrity of the system and touch upon the integrity of the arbitral function. And the right and appropriate remedy at that level is annulment under Article 52. But even assuming, Madam Van Leuven, that Article 49.2 is an appropriate avenue, nothing in the black letter and in the spirit of the ICSID Convention requires from parties to ICSID disputes to exhaust that avenue before going to Article 52. I think that if this committee was going into that direction, it would create a rule that was never actually endorsed or intended to be endorsed by the drafters of the ICSID Convention. Thank you very much.
Thank you, Professor Mbenge. Perhaps Mr. Ostrov would like to respond to this.
Thank you very much, Ms. Van Leeuwen. I'm surprised to hear arguments about the integrity of the system be used to justify not using a specific remedy that's built into the system to solve a problem. So if the case, if the applicant's case is that the tribunal failed to decide this question, and the system includes a specific rule to resolve that in 49.2, then with respect, it does not hold to say we should use 52.1 to blow it up, rather than using the narrow systemic relief that's available under 49.2. And otherwise, if the concern is, as was also just said, that there's a fundamental error, then the appropriate thing to do is to seek annulment. There, that would only be if actually the tribunal decided that it had competence, that it had jurisdiction, and the applicant doesn't like that decision or feels that it doesn't understand that decision. In that case, the appropriate remedy is 52.1e, saying, well, please state the reasons. So it is difficult to understand. The 49.2 gives 45 days. The system is supposed to protect itself, be protected with a short window to ask for a decision on something that was missed. And 52.1e is there to say, if there aren't reasons, let's look at it there. And the applicant did not invoke either of those. Thank you.
Thank you.
Thank you very much. I think that concludes the arguments on the substance, unless either party wants to raise anything else on the substance. I'm looking at my screen to see if anybody's jumping up, raising their hand or anything similar, and they're not. There is one point that is obviously outstanding is how the parties propose to deal with the costs of these proceedings in terms of timing and form. And I should say, speaking for myself at least, that I'm not inviting lengthy submissions. The parties have both been very sensible in their approach to these proceedings and cooperative, and we imagine that that is likely to continue in terms of seeking agreement on timing and form of cost submissions. So I was going to suggest that we leave that to you and you come back to us within a relatively short period with a proposal. Is that acceptable, Professor Mbeng?
Yes, thank you very much, Mr. President. This is acceptable to the Republic of Madagascar, and we are looking forward, as usual, to engage in a cooperative framework and spirit with councils for respondents. So thank you very much.
Does that also work for you, Mr. Ostrov?
Yes, thank you, Mr. President. It would be shocking if this was the one issue we were not able to find some kind of agreement on between.
Never say never, Mr. Ostrov. With the, I understand that ICSID will shortly be sending out a request for a further advance on funds, which, whilst it is unlikely to be welcomed by anyone, will not be a surprise to anybody either. But so that's just by way of forewarning. With that said, are there any further points that either party wishes to raise before we close this hearing? Professor Mbenge, Mr. Stoger, any points you wish to raise?
Mr. President, if I could just jump quickly on the last element of information that you share with respect to the advance of funds. I would just at that level ask the committee and also the ICSID secretariat to be a bit patient with us, since we have to get in touch with some of the officials in the Republic of Madagascar, and sometimes delays might be caused. So we would just like ask also to counsel for respondents a bit of indulgence after we receive that, if there are some delays. I prefer to say it now so it doesn't come as a surprise.
That's understood.
Thank you.
We're sure you'll do your best to make it come as quickly as possible, because it's in everybody's interest to have the decision.
No, we'll do our best. Yeah, we'll do.
Anything other than that?
Other than that, we would like, of course, the Republic of Madagascar would like, of course, to thank you, Mr. President, and the members of the committee for your attention. We would like to thank also very much the ICSID secretariat and the service provider in charge of the transcripts for all the technical assistance and technical support. And we would like, of course, to thank our contradictor for a very interesting and stimulating discussion and debate during the whole afternoon. So thank you again very much, Mr. President, for everything.
Any further points that you wish to raise, Mr. Ostrov?
Thank you, Mr. President. I think the tribunal will recall at the beginning of our presentation that I had a figure that I repeated of 12 years and 10 months. So you could appreciate that our client is very eager to have a sense of timing. I know that's always a difficult question. And I did hear your remarks that timing could be affected by the payment on costs. But we were wondering if it would not be inappropriate, and please tell us if it is inappropriate, whether there is any sense of approximately how long it might take to have a decision on annulment.
I don't have an answer for you on that question, Mr. Ostrov, at this stage, but you should be assured that the committee is has already set aside time for further deliberations, and we are all three committed to rendering our decision on annulment as soon as we possibly can. Having all of us appeared in your shoes as well, we know how important it is for you and for the Republic of Madagascar to have a decision on this important application.
Well, then all that remains is for me to thank you for that, and for me to join in the thanks expressed by Professor Mbengue for the all participants and for the committee. We greatly appreciate the way this entire process has been run, and in particular the good cooperation between council in order to make a smoother proceeding as possible.
Well, for the committee, we would reciprocate and thank the parties, and particularly council, for their professionalism in the way that they've conducted this annulment application, which has been very helpful for the decisions that we have to make. And we know that it's not merely the people who've spoken and appeared on screen today, but that there are wider teams working to assist you in your presentations, and we thank them too. I also, of course, thank my colleagues, Ms. Van Leeuwen and Dr. Bettini. I don't know if either of them has anything further that they wish to raise at this stage beyond thanking people. They're shaking their heads. Good. We are very grateful to Mr. Gorel, the Tribunal Secretary, who's done a fantastic job running these proceedings and organising today's hearing in such an efficient manner. And of course, our court reporters in both languages. Thank you very much. I wish you all a good day or a good afternoon or evening, depending on where you are. Thank you, and that concludes this hearing today.
Thank you.
Thank you.
Thank you, Mr. President.
Good day.
Bye.
Bye-bye.
Bye.